As we move through the program, I will introduce each panelist, and when they begin their presentation, they may give you some additional information about themselves and why they have the knowledge for the presentation that they are making. They will also let you know how they want questions. Mostly the questions you need, if you have questions, you need to put them in the Q&A box. Some of them we'll answer as we go, some we will wait till the end. Some of the panelists will advise you that they want you to just go ahead and ask questions as the presentation moves along. If they finish early, they may at that point also take some questions. I am Judge Janet Hepper, the presiding judge in the 387th State District Court in Fort Bend County. I'm going to begin this morning with a short review about the new Texas standardized protective order forms. Let me share my screen. These forms became available on July 1st, 2024, but we have noticed in our court that many applicants or their attorneys are still not using these forms. So we thought this might be a good reminder for you and how this came about. So why do we have these forms? The 88th Texas legislature passed Senate Bill 48, which became Texas Family Code 85.0221, which are the standard protective order forms. And that required the Office of Court Administration here in Texas to create standardized forms for the application and issuance of the protective orders. The forms have now been created and are posted on the Office of Court Administration website. And here I also in this slide give you the statute in the Family Code that requires these forms. So note that a court's failure to use the standardized protective order form as required under subsection A doesn't affect the validity or enforceability of the protective order that's issued. And just a little bit. So the forms are divided into two groups. There are mandatory forms and there are discretionary forms. The mandatory forms include the application, the temporary ex parte protective order, the final protective order, and the MOAPS, the Magistrate's Order of Emergency Protection. It's kind of nice to have these forms, although they can be a bit confusing. And these are kind of checkbox form. I have a sample here later in my slides. So the discretionary forms are, well, the discretionary include a notice of the application, application in order to rescind a protective order, the motion in order to review a protective order, motion in order to modify the protective order, a motion in order to vacate the protective order, and then there's an additional order separating a wireless telephone service account, which is kind of helpful. A lot of people don't realize that that can even be done. Here's what the first page of the application looks like. So it's a fillable form, and you just go through and check boxes. The pro se parties who file protective orders are sort of familiar with this kind of form. This form is a little more complicated, and as you notice here, it's 14 pages long. This is what the ex parte temporary ex parte order looks like. One of the things and why I put this slide up is at the top of the ex parte order there, you should see where there is a place to put the hearing date and the court address. So you need to find out, like our court still at this point is doing protective order hearings via Zoom. So you need to know what kind of address to put there, but the court then can fill in the date and the time. Sometimes we are seeing these forms with no hearing date. The court can't grant a temporary ex parte order unless we're able to also set it for a hearing. So make sure that the form you use, and this is from the Office of Court Administration website, that form that you use is has the hearing notice at the top. Here I have a slide just with the resources. the Office of Court Administration, and there's the link for that. Just an FYI, the Texas Law Help website also has a protective order kit, and I give you the link for that and the link for Texas Law Help. The nice thing about that, if somebody comes to you and needs a protective order, but you're not able to represent them, you can send them to this website for assistance. This website with Texas Law Help also has some FAQs regarding protective orders and safety plans, and those FAQs can help them be able to fill out this form. And then that is all I have for these slides. Okay, so let me stop. All right. If nobody has any questions, we'll just check. Then I believe Maisha will just go on to the next topic. So the next topic that is going to be covered this morning is United States versus Rahimi. We're going to have a discussion on that, and the presenters are myself. You've already heard from me, and Maisha Coulter here, who is the Chief Executive Officer of AVDA, Aid to Victims of Domestic Abuse. Sorry, I see something in the chat box. All right, let me share my screen for that. And start the slideshow. All right, and with that, Maisha, and if you just let me know when you're ready for me to go to the next slide, I will do that.
You can go ahead and go to the next slide. Good morning, everyone. Thank y'all for being on this Zoom today. As Judge Heppard indicated, we're going to talk about the United States versus Rahimi. It is a case that was ruled on by the Supreme Court recently, and it was pending for a substantial period of time, almost 2 years. It originated out of Texas, and so it had a lot of implications for us here locally in many, many ways. Before we get into the case itself, I want to discuss the background and the facts of Zacky Rahimi and how we got to the point that this case made it to the Supreme Court. So Zacky Rahimi, in 2019, he and his girlfriend met for lunch and got into a fight. He physically drags her to his car. He hits her head on the dashboard. A bystander happens to be present as these events are unfolding. He gets her to the car. He notices the bystander, and he reaches into his glove box to get a gun. While he was reaching into the glove box, he was distracted enough that the girlfriend fled the car. She runs, and while she's running in the direction of the bystander. Rahimi gets out of the car, pulls out a gun, and starts to shoot in the direction of either the girlfriend or the bystander. It is not clear to this day. At this point, the girlfriend pursues and gets a protective order, a civil protective order out of Tarrant County. It's a 2-year protective order that included the girlfriend and the child that they share together, her and Zacky Rahimi. Next slide. In February 2020, the order found that Rahimi had committed family violence and the violence was likely to continue, that Rahimi posed a credible threat to the physical safety of his girlfriend and their child. And that was the standard at the time the finding was made. The order required no contact between the parties unless it was specifically to discuss issues related to the child. The order also suspended his license to carry a gun. And that is a typical condition of a protective order in this state, as well as in any other state for that matter. By May, Rahimi went to the girlfriend's house and began to contact her through social media. In November, he threatened another woman with a gun and was charged with an aggravated assault and a deadly weapon at that time. Next slide. This is Zaki Rahimi, and this is his one of his mugshots, and just a photo of some of his charges that were pending out of Tarrant County. And you can see that those charges ran from October 2021 all the way through October 18th, 2024. So this is post the ruling out of the Supreme Court. I don't know how this particular person became the poster child for this case, but as you can see, he was a bad actor, had a number of issues related to guns, violence, weapons. It was very typical of him to use a weapon at his discretion, if I can use that word. Next slide, please. The crazy thing about this was that he was not physically arrested he was actually, there were multiple warrants issued out for his arrest. Search warrant was issued. They were able to search his residence. They found pistols, rifle, ammunition, and a copy of, we're using the universal restraining order, but it was the civil protective order that was granted against him by the Tarrant County State Court. Rahimi was indicated to have been in possession of a firearm while under a domestic violence protective order. And he decided to fight this case because of the conviction related to the violation of the protective order, specifically around him possessing a firearm. Next slide. So while he was under arrest, the Texas police identified him as a suspect in at least 5 additional shootings. December of 2020, Rahimi allegedly shot into the home of one of his drug customers for talking trash about him. The next day, Rahimi got into a car accident, whereupon he jumped out of his car and shot at another car. 3 days from that event, he drove through a residential area, shooting his gun in the air. A few weeks later, while speeding near Arlington, a truck flashed in its lights at him, at which point he slammed on his brakes and cut across the traffic to chase the truck, all while shooting at the truck and a nearby car. 2 weeks later, while at a roadside burger place, I think it was actually Whataburger, but I'm not sure, Rahimi pulled a gun out and fired at the person at the front, at the cash register, because his credit card declined. Next slide. So protective orders generally have this language under 18 USC section 922 G8, and it actually says, it shall be unlawful for any person who is subject to the court order that they was issued after hearing of which such person received actual notice and at which such person had an opportunity to participate, restrain such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or the child, including a finding that such person represents a credible threat to the physical safety of such intimate partner or child, by its terms explicitly prohibits the use, attempted use, or threatened use of a physical force such as such intimate partner or child would reasonably expect it to cause bodily injury. Next slide. Actually, I think I'm going to turn it over to you so you can start talking about the legal process.
Okay, so again, we just saw the federal statute that was used. Rahimi was in federal court, and that was the federal statute that was used as a felon in possession of a weapon that was used to convict him. So he, as you noted before, he claimed that 18 USC, the 922 GH, violated on its face his Second Amendment right to keep and bear arms. So that's the statute we just saw. So the federal district judge denied his motion, and thus he pled guilty, and then he filed an appeal. So the Fifth Circuit initially denied the appeal, and then Rahimi petitioned for a rehearing en banc. Because there was an intervening U.S. Supreme Court decision in the Bruin case, and we're going to talk a little bit about that in a later slide. That case was New York State Rifle and Pistol Association, Inc. versus Bruin. A full panel of the Fifth Circuit reheard oral arguments and reversed the underlying guilty finding. So the U.S. Supreme Court then granted cert in 2023. And the result, on June 21st, 2024 of this year, the U.S. Supreme Court reversed and remanded for proceedings in compliance with their opinion. And one of the things that had happened in Bruin, and we're going to get a little more about that, and that then affected this Rahimi case, had to do with the historical going through and deciding the history of when the Second Amendment was approved, and sort of what was going on the history of gun control. So just to know, so it was a 7-1 opinion. Justices Alito, Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, and Jackson joined in the opinion. And then Justice Sotomayor filed a concurring opinion. And Justice Kagan joined her in that opinion. And then Justices Gorsuch, Kavanaugh, Barrett, and Jackson each filed their own concurring opinion, talking really about different parts of the overall opinion. Justice Thomas filed the dissenting opinion. So in delivering the opinion of the court, Chief Justice Roberts gives a very thorough analysis of the Bruin case and the challenges for courts balancing Second Amendment rights with the government's ability and regulatory tradition, stating that since the founding, our nation's firearm laws have included provisions preventing individuals who threaten physical harm to others from misusing firearms. As applied to the facts of this case, that particular statute fits comfortably within this tradition. He goes on to discuss the fact that the Second Amendment right to bear arms is not unlimited. And again, he also had a thorough discussion of the requirements of that particular statute. And Maisha just went over that in the previous slide on what is required proof for that particular statute. So in the end, the government concludes that our tradition of firearm regulations allows the government to disarm individuals who present a credible threat to the physical safety of others. And thus, that particular part of that law can be applied lawfully to Mr. Rahimi. So there were a few other findings by Justice Roberts. A couple of things, and we've put these in because these are the things you kind of need to look at if you end up being involved in this type of case. Justice Roberts says you need to look at what was happening at the time the Second Amendment was passed. But he also says the reach of the Second Amendment, as I noted before, is not limited. And it's not limited only to those arms that were in existence at the founding. For example, muskets and sabers. So you should keep this in mind when any cases that you might have, because again, it's sort of more arms. It isn't necessarily guns. Again, muskets and sabers. A saber is not a gun, but it's used as a weapon. Even when a law regulates arms bearing for a permissible reason, it may not be compatible, though, with the Second Amendment right to keep and bear arms. if it does so to an extent beyond what was done at the founding. And this we'll talk about this a little more. Additionally, so in Rahimi, the protective order was for 2 years. So the Supreme Court looked at that and said, so that means that was only a temporary limit. A challenged firearms regulation must comport with the principles underlying the Second Amendment, but he also said it does not need to be what they called a dead ringer or a historical twin to pass constitutional muster. And that allows you and gives you a little bit of an in because times have changed. That section, the section 922G8, applies only once a court has found that the defendant represents a credible threat to the physical safety of another. A little more to know, there is specific reference in the concurring opinions about the duration of the prohibition and a discussion of the history of firearms regulations and, again, societal changes. So there's reference to it in the concurring opinion, but they don't talk about what would happen. And these are questions that are still out there. What would happen if the protective order was for longer than 2 years? So we thought it was interesting. Justice Sotomayor, within her concurring opinion, she stated, because the dissent, and she's referring to Justice Thomas's dissent, which sort of said, no, he has a right to bear arms and you shouldn't be allowed to stop that even with a protective order. Because the dissent concludes that this 18 U.S.C. addresses a societal problem, which is the risk of interpersonal violence that has persisted since the 18th century. It insists that the means of addressing that problem cannot be materially different from the means that existed in the 19th century. So again, so the dissent is saying, well, history says this was what was going on. These are the weapons that were being used. And so if our law today isn't an exact twin of that, then it violates the Second Amendment. So that is so even when the weapons in questions have evolved dramatically. According to the dissent, the solution cannot be materially different even when societal perception of the problem has changed. And even if it is now clear to everyone that the historical means of addressing the problem have been wholly inadequate. Given the fact that the law at the founding was more likely to protect husbands who abuse their spouses than offer some measure of accountability, it is no surprise that that generation did not have an equivalent to this federal statute. Under the dissent's approach, the legislatures of today would be limited not by a distant generation's determination that such a law was unconstitutional, but by a distant generation's failure to consider that such a law might even be necessary. So again, this is Justice Sotomayor's way of saying we need to look at what was going on historically, but we also need to have a way to apply it in our case today. So let's talk a little bit about Bruin. So that was the case that the Fifth Circuit used to overturn Rahimi at the Fifth Circuit level. So Bruin was a 2022 case out of New York. The state of New York at that point required a person to show a special need for self-protection to receive an unrestricted gun license to carry a concealed firearm outside the home. So these two people, Robert Nash and Brandon Cook, challenged the law after New York rejected their concealed carry applications based on a failure to show proper cause. The legal issue in Bruin was, does New York's law requiring that applicants for unrestricted concealed carry licenses demonstrate a special need for self-defense, does that violate the Second Amendment? And in the end, the finding was that New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising, so the 14th Amendment due process, from exercising their Second Amendment right to keep and bear arms in public for self-defense. And I will say in the Rahimi Supreme Court case, they also talked about why, with the Second Amendment, why that was important. And it really, at the time it was put into effect, it was to allow people to carry a gun for self-defense. Okay, the finding, the right to carry a firearm in public for self-defense, is deeply rooted in history, and no other constitutional right requires a showing of special need to exercise it. While some sensitive places restrictions might be appropriate, Manhattan is not a sensitive place. Gun restrictions are constitutional only if there is a tradition of such regulation in U.S. history. So again, this was Bruin is another Supreme Court case. So that was the earlier case. Justice Alito authored a concurring opinion arguing that the effect of guns on American society is irrelevant to the issue. But Justice Kavanaugh authored a concurring opinion in which Chief Justice John Roberts joined, noting that many state restrictions required background checks, firearm training, a check of mental health records, and fingerprinting. And those are still permissible because they are objective, in contrast to the discretionary nature of New York's law. That case, though, also had a dissenting opinion from Justice Breyer. So in that case, Justices Sonia Sotomayor and Justice Kagan joined. Justice Breyer argued that states should be able to pass restrictions in an effort to curb the number of deaths caused by gun violence, and the court's decision severely burdens the state's efforts to do so. So again, and you go back to the concurring opinion here by Alito that says, you know, gun control, that's irrelevant to the issue of whether somebody should have a right, excuse me, to carry a gun. More recently, we've had a Fifth Circuit case recently come out in September of this year. And the reason we've put this up here is because it maybe pushes forward a little bit of what happened in Rahimi. So the Fifth Circuit decided this case in September of this year. Diaz was charged with possessing a firearm as a felon, which was the same thing as with Rahimi, in violation of 18 U.S.C. section 922 G1. He moved to dismiss the charges, claiming that the statute violated the Second Amendment both facially and as applied to him. So one of the differences in Rahimi is that Rahimi was claiming the Second Amendment was facially unconstitutional. And that meant that in Rahimi, he had to be able to show there were no possible reasons that you should not be able to carry a gun, and that it would be that would violate his Second Amendment rights to have a gun in his possession. In this case, which is a very high standard. So in this case, he was protesting and saying it violated his Second Amendment both facially, so on its face, and as applied to him. So his motion was denied, he was convicted. So in this case, though, unlike with Mr. Rahimi, who was, you know, threatening people all over the place, Diaz's criminal history included vehicle theft, evading arrest, possessing a firearm as a felon, which kind of came about because of drug use issues and drug sale issues. Nothing that involved assaulting other people. The Fifth Circuit found that at the time, okay, so this now again is after Rahimi, the Fifth Circuit found that at the time of the Second Amendment ratification, those people like Diaz who were guilty of certain crimes, and it could be theft, were punished permanently and severely, including permanent disarmament, so that he could be, the government could permanently keep him from having a weapon, even though what happened, his background, criminal history did not involve assaultive behavior. And then his conviction was affirmed. So one of the things you should take away from this is that this case shows how even without specific findings such that you would need to get a protective order, you could still get disarmament. And I think this maybe helps bring in, because we know for a protective order, you can get a protective order based on threats. It doesn't actually need to be something beyond that. So a couple things, other additional things here in Diaz. So simply classifying a crime as a felony, which now it's typically a felony if it's greater than 1 year in prison, doesn't meet the level of historical rigor required to be able to disarm somebody. You need something more than that. So not all felons today, people that we would classify as felons today, would have been considered felons at the founding. So again, they still are going back to what did history tell us? What was going on when the Second Amendment was originally passed? At that time, at least one of the predicate crimes that he was convicted under, and where his gun was taken away in the federal 922, it relied on theft. At that time, back when the Second Amendment was passed, it was a felony and would have led to capital punishment or estate forfeiture. There's a lot of this case, Rahimi, you need to look at that, because there's a lot of going back and looking at what was going on through history, so you get an idea of how, if these questions come up in a case that you have, how you might argue that to the court. So disarming Diaz fits within this tradition of serious and permanent punishment. So again, we note that the history reveals that the right to bear arms at that time, even at that time when the Second Amendment was passed, it wasn't unlimited. And even at that time, the government could prevent people who had committed crimes or were what they call quarrelsome from assessing weapons. So you need to keep that in mind, again, as you move through the cases that you might have. So some of the questions that, and Maisha, just feel free to also step in here. Some of the questions that come up here that were not answered in Rahimi is sort of, would the case come out the same if the protective order was a lifetime protective order?
How temporary? Yeah, is temporary. Obviously, we have 2-year protective orders, but protective orders can span for a number of years, past 2 years, and all the way through to a lifetime protective order being issued. So the issue of the length of time and the removal of the gun from the person who has a protective order granted against them is still out there and in question, based on the rulings that have come out of the Supreme Court. And even with Diaz, I don't think we have a resolution to that issue, so it could come up again.
And even here, and I think Diaz, at least for us in the Fifth Circuit, is that threats can be enough to be able to make those findings and take his gun away. Because in Diaz, none of the findings related to any kind of assaultive type behavior. And yet the Fifth Circuit said, okay, based on Rahimi and how the Supreme Court goes through and analyzes Rahimi, that should allow me to also permanently disarm him, even though his case wasn't assaultive behavior.
Yeah. The other question that comes to mind is, what if there was no evidence that a weapon was used, or a weapon, was there a weapon during the pendency of a protective order issue? So if you have individuals who have protective orders granted against them, but weapons were not utilized in the alleged facts related to the issuance of a protective order, does that mean that these individuals would be allowed to maintain their weapons? Could they challenge and take something like that instance back to the courts? Again, I don't know that we have a clear resolution based on the opinions that were granted and that were advised out of Rahimi.
So, and one of the arguments even for how temporary is temporary, because protective orders can be modified, temporary orders can be vacated. Does that make even a lifetime protective order potentially temporary? And we don't know the answer to that, but it is probably at some point going to come up. And so a thought is, would it be better to get your protective order for a shorter time period and renew it if you need it, or to push for a longer time period?
And Judge, let me ask you a question. What are your thoughts on getting a protective order for a limited time period and attempting to renew? Wouldn't there be the issue of new facts needing to be presented in order for you to be able to renew a protective order after one has been granted?
Yes, because my belief is that you need to show there's a continuing need for the protective order, but I might be able to get it even longer than 2 years, right? Again, how temporary is temporary? Is 5 years still temporary? 10 years? The Texas Supreme Court just this week heard oral arguments on a case that was a permanent protective order that included an inability to contact the children. And it really was a protective order to protect the children. And it's going to be interesting because the claim was, this is a lifetime protective order. Mom can't see the kids. So, well, that's like terminating her parental rights without having to meet the clear and convincing burden of terminating her parental rights. So these kind of things continue to come up, these kind of issues. And it's going to be interesting to see what happens as they work their way through the system. And even with what's a weapon. So the Texas or U.S. Supreme Court has clearly made it clear that the definition of a weapon has expanded since the Second Amendment was passed. But again, they specifically talked about, sabers and muskets, which is what you had back then. And so what's the definition of a weapon that would be enough so that I am able to disarm somebody and keep them from having a gun? And those are questions that are still out there. It will be interesting to see as more of these cases work their way through the system. And then a couple takeaways that we have here is to help and make sure that your protective orders that you're doing will meet the Rahimi language, because we put gun disarmament in our protective orders, right? That's one of the language, that's part of the language in the legislation. But you want to make sure, in case somebody tries to appeal that you have the findings, that even the specific language findings that Rahimi uses in the Supreme Court opinion, use that language in your protective orders. Maisha, you want to talk about this one?
Yeah, I want to just bring to everyone's attention that while Rahimi was pending, the Texas legislature was in session, and they did nothing to make any changes to the Texas law prohibiting weapons and ammunition possession under the protective order code. So we have an equivalent state law that prohibits individuals who have protective orders granted against them from having those protective orders. And many courts relied on that to maintain the status of our protective orders. There were a few, including the Harris County Protective Order Court, that removed the gun prohibition language out of protective orders while Rahimi was pending. But many state courts did not make that decision to do that. And unfortunately, there are a number of protective orders that were granted during that period of time that have no gun prohibition language in it, which is concerning. But most people in Texas, judges in Texas, if they issued and granted protective orders during the pendency of Rahimi, relied on the fact that the Texas state law also prohibits the use of firearms during the issuance of a protective order, when a protective order is granted against a respondent.
Well, and the Texas Family Code, it's mandatory.
Mm-hmm.
It's in there and it's mandatory that you need to have that language, sort of disarmament language, so that they have to turn in any guns that they have. So yes, we continue to do that. If we had a case that there was absolutely no testimony about a gun, then we might have taken it out. But the Texas legislature hasn't changed, and it'll be interesting now. I would think that this means they don't have to change. We were very concerned because we know, and as many of you know, how dangerous it is and how often guns are used to threaten and kill our victims of domestic violence. So a couple other takeaways. So I have a take care. Just think about how long the protective order should be in effect. What are you going to ask the judge to do? In this case that went before the Texas Supreme Court, and I've read the appellate case. I heard the arguments. One of the arguments was the application for the protective order did not state a length of time that protective order should be in effect. But clearly our legislature here in Texas allows, under certain conditions, for a protective order to be granted for more than 2 years, which is sort of the presumed length of time for a protective order. Also, keep in mind, Rahimi reminds us that the Second Amendment is not just for certain firearms, that's pretty expansive. You should know your judge wherever you're filing and arguing your protective order, and be ready to brief the firearm issue if it comes up. My belief is, as long as people are familiar with Rahimi and what our statutes say here in Texas, that should be good enough. Also, to think outside the box and remember that threats are enough. It doesn't have to be that somebody's been physically harmed in order to get a protective order. And we all know that even if there hasn't been physical harm, that threats are harmful. And with that is my last slide. Let me see if I can escape out and stop my share. And so we can see if anybody has questions. Oh. Let's see if we have, if anybody.
I don't see anything in the question and answer that has not been addressed already, or that references our presentation at this point.
If anybody has any questions, now we are happy to take it. We started our session a little earlier, so it has finished a little early, and otherwise we will give time back to our next group, which can be nice. All right.
There's a question. It says, how can firearm holders be protected in OP hearings? So I guess the question is, if you have a firearm and you are.
Okay, I'm gonna let you answer that one, then we'll get the next one.
Yeah, I think I'm not sure that I understand the question. I'm assuming they mean PO hearings. So how can a firearm holder be protected in PO hearings is what I'm assuming the question is. It says OP. I guess if someone has a defense against the application for the protective order, then that is where their protection lies. If there was an incident that caused a party to pursue an application of a protective order against someone who has a weapon, who owns a weapon, is, then they have to defend against that protective order and wholly defend to the point where it is not granted against them. And that in and of itself will allow them to be protected against the removal or surrendering of that firearm. If they don't have a credible defense, then unfortunately, that's the end of it. That's the whole point. People who have protective orders being granted against them during the pendency of that protective order being granted will not be allowed to own or have a firearm in their possession. And then there was a question of, may we alter the forms? I'm not sure. That's a good question. I know that we're all supposed to use the format of the forms that are now in effect. I don't know if it depends. I guess it depends on what the alteration would be. I don't know if it would change any of the substance of the form or the pleadings involved, that it would be a problem. But again, I don't know that that question has been raised in any case where there's been an alteration to the forms or the what is required to be in an application for a protective order. Are you aware of anything, Judge?
No, and I see Barbara Stalder is typing an answer, so we'll see what she says too. So the forms are pretty thorough. You may end up attaching a separate affidavit for your ex parte order. The statute is clear that even if the standard form isn't used, that it's still effective, but there's some question about, even I guess what you mean by altering the form. So that makes a difference. And then Maisha, you probably know this better than I do.
I do. Is there a place? Yes. So I just actually did a presentation with Judge Warney and Lieutenant Klofka of the Sheriff's Department. So we have had a gun surrender program in Harris County now since 2018. And Klofka, while doing that presentation, indicated that they have collected more than 200 guns as a result of protective orders being granted against people who have weapons or own firearms. And again, those firearms are collected at the time that a protective order is granted, and they are held for the duration of time that that protective order is in effect, and then they are released back to that individual. And he also confirmed that they have released back 61 of those weapons since they have had the program in effect. So we have a gun surrender law here in Harris County, and we have a program that is being supported by the Sheriff's Office. So if you find yourself with a case where you're pursuing an application for protective order, weapons were involved, and you are aware that the respondent has a weapon in their possession, you can ask at the time that they participate in this gun surrender program, have that weapon released to Harris County, and they will hold it, store it, and maintain it. And I mean maintain it, meaning that it will be in good condition at the time that it is returned to the individual, based on what I know to be true from the person who is in charge of that program. Other counties have some gun
I believe that Fort Bend County also has a program, and there's also a form. If the person is claiming they have no guns, there's a form that gets attached to the protective order that they have to complete saying that they don't own a gun. But yes, Fort Bend County, I believe, also has a surrender program, because otherwise, what do you do with your guns? Oh, here we go. Does that gun apply for emergency? Yes.
Yes.
Yes, and
yes, you can get it for 60 to 90 days as well.
Yeah.
Yes.
So it is in that order. In fact, I recently double checked to make sure, since we had Rahimi, to make sure that it is still part of that statute. Our legislators come back here in January I have not heard, and maybe you have, Maisha, on whether they're looking at any changes to the protective order statutes that would come out in the spring.
I have heard from different entities, and I sit on the policy team for TCFE, which is the Texas Council on Family Violence. There is some concern about the removal of the second prong in the protective order language, and we're not going to speak on what has been happening across the state, but there is a lot of conversations related to the removal of that prong and what has now appeared to be protective orders being granted. People are going back and asking for protective orders for, situations that happened, many, many years ago. And based on the removal of the prong, courts feel obligated to issue protective orders where there may not necessarily be a demonstration that it is likely to continue because these individuals don't have, situations and circumstances that are happening today. They are just basing the application on the fact that family violence happened in the past, and the past could be 2 months ago, 2 years ago, 20 years ago, technically, based on the new protective order language. And so there is some talk amongst those who are in the policy making world about how to address that. I don't know that there's a whole lot of cases where that's happening, but I've heard of some, and I've heard people talking about how do we fix that.
Well, and you may hear our next topic is a protective order overview, so you'll hear a little bit about that. I have one more question here. Section 7 of the form allows for other terms, and I've used that section to add child-related terms such as possession and access and child support, and listing personal items to be retrieved. And I'm just going to be brief on that because we're getting a protective order overview here shortly. We mostly in our court, we may do something that would be more of a temporate orders, only because my concern is that people then will rely on possession and access and child support orders in that protective order. And when that protective order expires, my belief is those orders also go away. So we don't want people, we want people to come in and actually get either, if they need a divorce, but custody orders, separate custody orders, if that is what they really need. So with that, I think we have one more.
I think there's a comment, not necessarily a question.
Yeah.
It says a lot of pushback currently in the 280th Harris County concerning the remoteness of family violence, which is not a consideration under the current statute. And that is correct. There is no consideration now for when the family violence occurred. The prong that has to be met is that family violence occurred in order for the courts to issue a protective order. So again, I know that that has been an issue, and I know that there is talk about how to repair the fallout of the removal of the second prong that has existed, well, my entire practice life, and that's more than 2 years. So yeah, it is unusual times for those of us who've been around for 20 plus years doing protective orders.
So just keep watch on that. Mm-hmm. And with that, we will turn to our next set of speakers. Thank you, Maisha.
Thank you, Judge.
Next, we will have a protective order protective order overview, stalking, harassment, protective orders, what you need to know. And with that, their speakers will be Vanessa Goosen. Hopefully I pronounced that correct, Miss Vanessa, who is Assistant District Attorney, a lead attorney in the Protective Order Division in Harris County's District Attorney's Office, and Barbara Stalder, who is one of the managing attorneys in the Houston office of AVDA. And with that, I will take a step back, and you guys should be able to share your screen and do your stuff.
Thank you, Judge. Good morning, everyone. I am happy to present and kind of go over what our office does, and I'll let Judge Stalder give a brief interview.
Hi, everybody. My name is Barbara Stalder. I am the managing attorney here in the Houston office of AVDA, And some of you know me from being the former judge of the protective order court here in Harris County. And I also was a clinical professor at U of H Law Center with Judge Heppard when we were both over in the clinic. And today we're going to talk to you about protective orders. Ms. Gosen's going to talk to you a little bit about this, and we're mainly going to focus on stalking today, but she's going to give you an overview of the protective order process. It's basically the same for everyone. So whether it's coming from the DA's office or coming from your office, it's basically going to be the same. So Vanessa, go ahead and take it away.
Thank you, Judge. All right, so protective orders in Texas, right? As Judge Stalder said, protective orders are going to be the same whether they're coming from our office, the district attorney's office, or your office. And so it's very generalized information that would be applicable if you were filing a protective order for an applicant. And so what is truly a protective order? Remember, a protective order is a civil lawsuit. We are serving the respondent, the abuser, but instead of asking for money, you're asking the court to enter an order of protection to protect from some dating violence, stalking, harassment, or sexual assault. And it prohibits the offender from going to home, work, school, even in agreed protective orders or defaults. The court can be pretty wide in, your church, your gym, or someplace that applicant typically visits. And a violation of this civil document, this civil order, is a crime. And so it's a violation of a protective order would be the charge at a misdemeanor level, but it can be up to a felony. In addition to those criminal penalties, you can also file an enforcement out of the same court that the order was issued from. So it's two reliefs possible with a protective order. And again, as the prior speaker stated, there are no firearms for the abuser while the protective order is in effect, and that's non-negotiable. So it provides this heightened level of security, of safety for that victim. And lastly, my last 2 points are that others can enforce. So your neighbor sees the abuser near your house, you're not there, you're at your victim or your applicant's at work. Other people can call and enforce that order, and that order is enforceable in all 50 states. So it's a great order that is that next step for victims becoming survivors, protection for the survivors of domestic violence. Now, there are 4 main categories to obtain a protective order. That first one, and the one we frequently speak about, is family violence, right? Under Title IV of the Texas Family Code. And that's typically just a 2-year protective order. That's what we often refer as our vanilla 2-year protective order. But there are different bases for obtaining a protective order, and Chapter 7B of the Code of Criminal Procedure enumerates several offenses in which you can obtain a protective order, which are biggest basis is stalking, sexual assault, and human trafficking. When you are filing a protective order, you can plead 1, 2, 3, 4, a combo, all, or and so you need to make sure that when you're interviewing your client or your applicant, you see which bases you can file on, because it opens or expands the length of the protective order, and it also prohibits some modification. And so I will talk about that here shortly. But regarding family violence, so just that vanilla protective order, you do need to have the applicant and the respondent need to have some sort of relationship, whether that's dating, so boyfriend and girlfriend, husband and wife, parents of the same child, even dating violence, meaning a triangle type of situation. So prior ex-boyfriend is harassing the new fiance. Triangle type of situations also establish that type of familial or relationship that is required under family violence. Also a family member, so what you would know as brother, sister, uncle, it is through, it's up to the third degree. And so you can't go as far after the third degree. And lastly, household members. So roommate type of situations can also get protective orders under just family violence, either current or previous. All of these subsections of a relationship are current or previous. And so a lot of people say, well, they're roommates. They don't have any type of relationship. Roommates or household members can obtain a protective order under just family violence. Now, as the prior speaker stated, the burden or the standard now is just has to prove that family violence has occurred. Prior to September 2023, we had that burden, that additional prong that it's likely, we had to prove that it was likely to occur in the future. From my perspective as a proponent of protective orders and an opponent of domestic violence, obviously, I thought this was a great, monumental, and significant and amazing amendment to this burden, because it really does penalize and reward, on one hand, penalize offenders and abusers to deter domestic violence, right? You hit someone or you threaten someone the first time, technically you could have a protective order entered against you. And there goes your Second Amendment right to firearms. So it is a great move, but then we get into all the problems with a remoteness of these prior or that one incident of domestic violence. But technically one incident of domestic violence, of family violence, is sufficient. And threats are enough. You don't need to have black and blue. A threat of violence is enough. And typically, as stated, the length is 2 years. Now, if you include that the offender has committed an act that constitutes a felony offense, it's not necessarily that he has been or she has been charged. It's just that there has been some act that could constitute a felony. That protective order goes from 2 years up to lifetime, not that you automatically get a lifetime. And so when you're interviewing your client, you're interviewing that victim, you need to establish, do I have an act that could constitute felony violence? And I've added a quick guide for pleadings regarding what could be categorized as family violence. So a threat, I'm gonna kill you, I'm gonna punch you, I'm going to, if you don't stop crying, I'm gonna beat the F out of you, I will destroy you. So those are all family violence. Felonies, right, is your strangulation, assaults during pregnancy, different types of aggravated assault. So if there's a firearm, a weapon, it doesn't necessarily have to be a firearm. And so I've added some quick guide for pleadings on what is a felony. Now, Chapter 7B, which doesn't require a relationship, if you go to Chapter 7B, you can actually click on these offenses, and it will delineate which offense is protected and you can get a protective order. It specifically says sexual assault or abuse, indecent assault, stalking, or trafficking. And so with these offenses, a relationship is not required. And so I urge everybody, if you're assisting in drafting or you're assisting a client in obtaining a protective order, you always, even if you think you just have a vanilla family violence, go through Chapter 7B, see what offenses these acts could fall under. Don't limit yourself, because Chapter 7B protective orders cannot be modified by the respondent, only by the applicant. And so it's an incredible way and tool to secure this protective order without any type of future modification. And one of those, now I'm going to focus just on stalking, right? Stalking's under my Chapter 7B Code of Criminal Procedure. So again, it does not require any type of relationship. The person does not have to be charged and gives you up to a lifetime in length. And again, it cannot be modified or removed unless, right, there's an appeal process. That's really the only method. What is stalking? A lot of people are confused and think, oh, it's hiding in the bushes, right? That's what we see in the movies. That's what we hear about. And those those things still occur today. But it could be more than that. With the use of technology, with the low cost of Apple AirTags, stalking has kind of flourished, unfortunately, into a very complex and out of the box type of situation. So don't limit really when you're analyzing your case for whether when you're going to file protective order, don't limit yourself and think this isn't stalking, that he's never hiding behind a bush or she's never hiding behind a bush. Really focus in on what the acts have been. And again, this is just the law under for stalking can be found under Chapter 7B, and it's that 42072. So make sure that you click on it, you start there. You must plead every single basis is in your application. So these are our pleadings for the DA's office. So constitutes family violence. You could include felony here, but in the alternative and without waiver, we're also going to show the court that there has been stalking and harassment. Your pleadings are what your relief the court is bound by, right? And so you have to make sure it's better to overplead, right? Without being frivolous, it's better to overplead and open that door of the different basis for obtaining the protective order, because the court is bound by what you've pled for. So if you don't plead for stalking without an amendment to your application, you're going to be bound by just family violence, and you've basically leveled yourself out to just a 2-year protective order. And what is stalking? So a person commits an offense if the person on more than one occasion and pursuant to the same scheme or course of conduct that is directed at a specific other person knowingly engages in conduct that one constitutes an offense under 4207. 4207 is harassment. And so with stalking, it starts at first harassment more than one time, or something that the actor knows or reasonably should know the other person will regard as threatening. And it could be threatening to bodily injury or death for that person, or the offense will be committed against a member of the other person's family or household, an individual with whom the other person has a dating relationship, or the other person's property. And so one thing to note, or two things to note about the stalking statute, is it has to be on more than one occasion, right? So family violence is that one incident. With stalking, it has to be more than one occasion and pursuant to a scheme or course. And the other thing I want to highlight as well is that the other person's property. From my experience in practicing before the 280th, she's knowledgeable and very, I guess, concerned about destruction of property of the other person. And so when you have someone that's repeatedly breaking, I've had cases where they're breaking potters or plants outside of their home repeatedly on different days. Although it's not a threat directly to that person, the other person's property, that would give me sufficient basis to apply at least for a stalking protective order. So look at your facts. Has the abuser threatened, harassed, not only them, but broken their property? Could give you the basis for a stalking protective order. And so I have included the harassment statute there that says that they, initiates that communication, and in the course of the communication makes a comment, request, suggestion, or proposal that is obscene. So sometimes requests for to be intimate outside of, this is my trainer, or this was my doctor, and they've repeatedly text me inappropriate photos and requests for intimacy without any type of relationship or anything, could give you that stalking protective order. So there's a lot of, it's broad, it's very broad. That's what I would say with stalking. And I just go through again the harassment. So make sure that what's required findings under Chapter 7B. At the close of a hearing under this subchapter, the court shall find whether there are reasonable good grounds to believe that the applicant is a victim of these offenses. And if the court believes it, then the court shall issue the protective order that includes a statement of the required findings. And just a quick side note, a conviction or placement on a stalking or sexual assault, it meets your burden. So also make sure that when you're interviewing your applicant or your client, make sure to say, has this person ever been convicted of or placed on deferred? Is there a criminal case pending? And if, go to the district clerk's website and see if that information. And so your final protective order needs to have that language as well. Again, for duration of a protective order, the stalking protective orders could be issued up to lifetime. And so it really expands that protection for that victim. It provides a very lengthy amount of time, 5, 10, 20 years. It doesn't have to be lifetime, but it does expand that amount at least. And stalking protective orders cannot be modified. And so the only person that could modify would be the applicant that would make that motion to the court. But other than that, unless it was overturned or appealed, you would have that protective order in effect for the duration that it was granted for. So again, stalking must be pled. Remember, when in doubt, if you feel like you have at least some sufficient ground to make that argument, I'm not saying to just plead everything and be frivolous, but just if you feel that there is at least a minutiae amount of evidence that you could meet your threshold, make sure to include that in your application, and does not require a relationship of any kind. You can be stalked and harassed by your neighbor, a friend, an anonymous person, someone you don't know, obviously, and you don't have to prove that future stalking will continue. But remember, you do need to prove that scheme or course of conduct, and can get you more than 2 years. Guilty or deferred is sufficient to meet the burden, and stalking must be in your final order. And again, stalking protective orders cannot be modified. How do you prove stalking, right? How do I show the court? It can be complex, difficult, and challenging because you have to prove that scheme and conduct. So look at, again, charging instruments, judgment, probation docs. Were there any MOEPs? Are there any bond conditions? Has this person violated those to be able to show this conduct, this repeat pattern? I would say that although no protective order really requires any admissible exhibits, right? Evidence or testimony is evidence of domestic violence or stalking. I would say that because stalking is complex and requires that scheme, that you do need documentation. It's not a requirement under any type of code, but I would say in order to obtain them, you need this track or this log or this documentation of calls, text message, social media activity. Do we have ring door videos, letters? And remember that you cannot just meet harassment alone. You're showing this scheme. Prepare your witness. Make sure that you talk about, I think one very important question for a stalking protective order is that you ask your client or the applicant prior to court, when's the last time you spoke to this person and what was the contact? Because you want to make sure that, was there any break to that scheme? This person may, and because of the cycle of violence and all of any other things, right, be in this DV cycle and relationship, go back to the abuser, go back to the offender, because this is why the stalker is doing this. And so we want an unbroken chain or scheme to be able to substantiate that burden. And here are some examples. this is just, again, an example. It doesn't have to be this thorough. Do not be discouraged if you don't have the documentation, but in preparation to make sure that you obtain a stalking protective order, you want to make sure that you get any and everything that you have. Maybe it's only the incident cards that you have from all the reports that the victim made to the police. Maybe that's all you have, but show that documentation. And what are some examples, right? Some examples could be these letters to the windshield with the flowers. Some could be repeated letters, and you can see here the return address is B.Abe, so Babe 69 Lovers Lane, ready to come back, Texas 69 69 69. And text messages like, I hope you understand, I will never let you be with anyone else. And so maybe you don't think that this rises to that blank vanilla stalking that we have all ingrained, or that bias that we've created of what really stalking is. But as the courts become more aware, as technology has become more modernized, then we need to be open to hearing our applicants out and understanding that they could be stalked at this point by the offender. From my experience as the lead prosecutor in this division, I've seen stalking protective orders to be some of the longest protective orders I've obtained. Stalkers will not stop. They may pause, but stalkers are some of the most serious cases that we see. And they may not just may stop from that person, but they will continue their obsessive behaviors to another victim, unfortunately. And it could have some mental health, obsession, delusion, manic. So take these cases very serious. As an attorney, I would urge you to check your pleadings. You're bound by them. Plead DV, judge finds stalking and grants a 20-year protective order. Our appeals, that could be grounds for reverse, and that's the worst thing you want to happen. You prepare your applicant. How did these calls make you feel? This may be the first time that your client sees this abuser, right? I don't know this person. He's or she is stalking me, and now I have to go to court. This is the first time they're going to come face to face with this person. So make sure you inform your client, your applicant. I think one also good rule is our criminal charges pending. Always check your district clerk's website. So as you are obtaining, or I'm sorry, in the process of preparing for a protective order, investigate and determine. Start at, do I have domestic violence? Is it one of the offenses under Chapter 7B? Is there a combo? Should I go ahead and plead to expand how much of the protective order length the judge can give me? Ask for a temporary protective order, I would say always, and remember to prepare for your hearing. You have to serve the respondent. And I, as a prosecutor, would tell you that personal service is required, because if I, as a intake prosecutor, am accepting a violation of a protective order charge, I have to prove intent. And so in order to prove intent, I have to prove that this offender knew that this order existed. So another tip is, I know it's very difficult to tell a victim, if you can't find the respondent, we don't have an address to serve him, you can't obtain a protective order. But unfortunately, if we obtain a protective order without personal service being effectuated, it's difficult to accept a charge in the criminal world for violation of a protective order, because I'm unable to prove that the offender knew about the existence of this protective order. As far as your hearing, the respondent, after being served, does not necessarily have to show up. You can move for what's known as a default, or if the offender shows up, you can try to pursue an agreement. And if he or she does not want to agree to the protective order that you've proposed, you would proceed with the trial. And so those are the three outcomes if the respondent has been served. And again, I would always suggest prepare as if you're going to trial, because most of our agreements work out because of the thoroughness in which we prepare for court, the thoroughness of their exhibits. And when you're speaking to that offender, you say, here's what I have. I have 20 exhibits, or I have 4 exhibits, and these are how strong they are. And again, always prepare your applicant. And that's it. I will turn it over to Judge Stalder for her presentation.
Hello, everybody. Thank you, Vanessa. That was really, really good, and it sort of segues into my particular topic. I am going to make a good faith attempt to share my screen. I want to talk to you about stalking and their behaviors and the things that I think you all need to know. This particular presentation comes by way of the American Bar Association Commission on Domestic and Sexual Violence. It is a really good PowerPoint. I think that you all will get a lot of information out of it. If I can make it go again, let's see, may not be able to. It's first time I'm using it, so, but I want to expound upon something that Vanessa said about the proof that is required. There are many different ways that you can prove stalking behavior. It will take some time to develop what we call a stalking log. And in this particular PowerPoint, there is a stalking log available. In addition, you can just Google stalking log or go to the National Network to End Domestic Violence, and they have a lot of resources there, particularly when it comes to stalking. I want to talk to you a minute about context. Context is critical. There's an example here that when I read this, I thought, wow, that really made me stop and think. There's an example where this woman got into her car to head to work. Her car doors were locked, and on the driver's seat was a Corona beer bottle or beer cap. Now, she called the police, and you may be thinking, well, why did she do that? Well, one of the reasons why she did it is, one, her doors were locked and she did not believe that anybody had been in her car. But she was also a recovering alcoholic, and she had just celebrated her sobriety. And she had sent out some or she had gotten some messages from some of her friends about her anniversary, her sober anniversary. And the stalker or the suspect that she believed placed the beer cap in her car had been somebody that had been stalking her and knew that seeing that beer cap would be an emotional trigger for her. So alone, that beer cap may not mean anything to anybody, including a police officer. But you have to be able to give context to what that means. And that's one of the reasons why Vanessa talked about talking to your clients, getting and delving deeper into what they know and what they don't know, and what behavior has been happening, in addition to what kind of communication contact has been happening, and if the individual has told that particular suspect to stop. There was a question in the chat about unbroken communication. You can have communication where someone has said, stop, I don't want you to contact me anymore. And they may not do that for a few weeks or a few months, but then they start back up again. One of the things that you do need to know about stalkers is that they may stop for weeks, months, or even years. One of the things that we know about stalking is that during the course of a year, there's more than 5 million women that are stalked and men more than 2 million. So it is not just a female issue. We know that it happens to men. In fact, a lot of the cases that I saw on the bench involved men being tracked by women, where they would do harassing behavior. They would key their car, slash their tires, leave ugly notes and threatening notes on their vehicle. They would also make threats to whoever the person was that the male was dating. And so those behaviors are all harassing, and they are also considered under the stalking statute. 1 in 6 women and 1 in 17 men will have the stalking incident during their lifetimes. In addition, we know that women are more likely than men to experience stalking. We also know that the majority of the victims that report the offender is male. We know that the majority of victims know the offender. And we also know that 18 to 24-year-olds experience the highest rate of stalking among adults. I don't know about you, but to me, that is alarming. When you think of that age group, then what you have to ask yourself is, what are we doing to reach those people, to educate them, and to be able to assist them much earlier in life, to be able to then have them be more aware of these behaviors so they will not get involved in them to begin with. Now, not everyone is going to have a dating partner that is going to stalk them once they break up, but we do know that stalking is a predisposition to homicide, and it does more likely occur when people had a dating relationship or a marriage relationship. The marriage relationship has ended, or the dating relationship has ended, and the person on the other side, the stalking person, does not and cannot accept that the relationship is over. Here's some of the data that shows that it's a current partner or a former partner, an acquaintance, stranger, family member, and person of authority. What we know about stalking behavior is this framework. There is surveillance, there's intimidation, there's life invasion, and there's interference. When we talk about surveillance, we're talking about them following them, they're watching them, they're waiting for them, showing up, they're using the tracking software, which I'm going to talk a little bit more about in just a few moments, or they get information about the victim either from other people, or they go online and use some of those people finder websites. And they'll also do proxy stalking. What does that mean? They get somebody else to do it for them. We've seen children, we've seen other family members, we've seen friends who all will do the proxy stalking. Sometimes it's done under the purview of, oh, well, I just want to make sure they're okay, or I think they're dating somebody that may not be on the up and up. And so, I just want to make sure that they're going to be okay. I don't want anything to happen to them. When in all reality, it's done because they're obsessed with them and they can't dream that they would leave them behind. When we talk about life invasion, we're talking about unwanted contact at home, work, etc. The key word in this PowerPoint for this slide is unwanted. As Vanessa said, you cannot have a continuing conversation with the stalker or the person you believe is stalking you if you're engaging with them freely and voluntarily. You have to be able to say, stop, I don't want you to contact me anymore. If you contact me again, I'm calling the police. If you contact me again, I'm going to file a protective order. You have to make that decision to say stop. So when you're talking to your clients, make sure you ask those questions. And in fact, if they have text messages or emails or any other video or audio, you want to see that. You want to read it because you want to know what they're saying or how they're responding. So then you can make a decision on whether or not this will meet the burden in court. People showing up. They show up at the workplace. They show up at the gym. They show up at the grocery store. I recently had a client, her and her children had moved, and they were at a grocery store, one that they had never been before with the husband. It was a divorce. He showed up in the middle of their shopping. She had absolutely no idea how he got there. She learned later that he had put some spyware on her phone so he knew where she was. So it may not be or seem like it's stalking if they're showing up to your home, but if they're showing up places where they normally don't know you're at, then you need to have your client pause and figure out whether or not there's some sort of device or software or some other reason or way this person is gaining access to their location. Phone calls. Phone calls, day, night, doesn't matter what the time of day, over and over and over again. I have seen call logs, as I'm sure Vanessa has, where the individual who is doing the stalking behavior has called them repeatedly, one after another. Within the span of an hour or 2 hours, there could be 200 calls made. That is stalking, period. It's also harassing because it's something that is placing the victim in fear of their life, but it's also done to harass, annoy, alarm, abuse, or torment them, which is part of the harassment statute and including the stalking statute. Property invasion. They show up to your home uninvited in the middle of the night, banging on the door, or they show up to a family member's house, or they come to your workplace and they break your windshield on your car. They also can use public humiliation. What if you have a client who made intimate videos or sent intimate photos to the person who is doing the stalking behavior? And it was done during the course of the relationship, and it was voluntary and freely done. But now that relationship is over with, and this individual is using them and using that video or those photographs as a means to threaten them, harass them, try to get them to come back, and make threats to send that information to family members, to friends, to employers, or post it on social media. Those types of public humiliation could fall under the revenge porn statute, so that is something to consider. You also may have them showing up at a birthday party where they're not invited, and they start making a big scene in front of all the friends and family. That can also be considered public humiliation. And also harassing family members and friends. I think that is one of the other common ways that they do harass you is they start calling the family members, especially the mom or the dad or the siblings, and begging and pleading for them to talk to the victim and trying to get them to come back to the relationship. Or if there are charges that have been filed, criminal charges, trying to get them to drop the charges. Interference is the third mechanism. Financial and work sabotage. I talked a minute ago about sending those intimate photos to their boss. I actually had a client whose abuser, there was a domestic violence case and a stalking case, where the individual sent those intimate photos to their employer. In addition, I had a client who worked in a law firm, and they were trying to get them to get fired from their job. And they contacted the law firm and made false allegations about this person's work performance. In addition, I had a client who worked in the medical field who was doctoring information and then tried to tell the employers and the supervisor that it was our client who did it. Fortunately, the email thread or the documentation, the technology was such that they could see that it came from his computer and not hers with his logon information. Custody interference. I would bet we see this on a daily basis, where you show up to where the client shows up to the pickup and drop off and no one is there. They keep the kids for longer than what they're supposed to. They don't return the kids at all, or they show up at the designated time, they're not there, and 3 hours later, they text the victim and say, well, where are you? I'm at the drop-off location. They try to prevent them from leaving. This is also a big one. If there is still a relationship going on, but the individual is trying to leave, we often see that they're blocked physically, that their car keys are taken away, their phone is taken, they use the children as leverage. So this one is a big one. They prevent them from leaving. Road rage. I haven't seen a whole lot of road rage, but there was a case when I was on the bench where the woman was driving down the road and the guy was behind her and he tried to run her off the road. There were no weapons involved, but he did try to run her off the road. They attacked family, friends, and pets. I'm going to include children in this because I think children are the biggest that abusers and stalkers use the kids the most when trying to interfere with a victim trying to leave. They will often tell the victim that they're never going to get custody, that they will take the children and they will move and they will never find them again. They will also use family pets. I have seen recently where pets have been killed, where pets have been harmed physically, or they threaten to take the pet away and they wouldn't ever see that pet again, much like the children. And then there is the physical or the sexual attack, where they physically harm the victim or they sexually harm them. There's a lot of coercion that goes into sexual assault in relationships. So do not rule out a sexual attack simply because the victim may have given in. You need to delve a little deeper and find out, did she give in because she was threatened? Did she give in because she was coerced? Why did she give in to the sexual conduct? Or were they in the middle of a sexual act and she said no and he continued? And I'm using the she here just as a frame of reference. Keep in mind, men are victims as well. Oops. Sorry about that. And the last form is intimidation. Intimidation, I think, is one of the bigger issues in stalking is that they make threats. Sometimes they make threats to harm others. They make threats to take children away. They make threats to expose intimate photos or secrets. Again, I've talked about property damage, symbolic violence. I'm not exactly sure of an example for that. Forced confrontations, they show up, public place, they make you deal with them, even though you've said, no, let's go to a private place, and they force sort of in that public humiliation. Another big one that I see is that they threaten to harm themselves, kill themselves as a mean of manipulating the victim into staying or going back to them. I've kind of gone over these already, so I'm going to move forward to the correlation between stalking and domestic violence. In this particular data shows that in 2010, there were 45 incidences of stalking within domestic violence. In 1998, there were 286. And in 2017, there were 66. I'm not sure exactly why this data shows sort of what it showed. Oh boy, I just went forward real fast. My apologies. Why it shows that particular data. However, we do know that stalking is more prevalent in domestic violence cases than it is in stalking alone. We know that the most dangerous time is when a person is leaving, but we also know that stalking is a precursor to domestic homicide. We know that women who were abused and stalked experienced significantly higher rates of the following than women who were not abused but were stalked. They had the verbal abuse, degradation, jealousy, control, serious threats, severe physical violence, sexual violence, threats to kill them, threats with a weapon, being beat up, attacks with a weapon, and injury. I'm not going to go over the power and control wheel. It will be in the PowerPoint if you want to read more about it. An intimate partner stalking, which is what I call the domestic violence stalking, they're more likely to approach the victim, be interfering, insulting, and threatening, use a weapon of some sort, escalate the behaviors quickly, and reoffend. In intimate partner femicides, 85% of attempted and 76% of completed femicides, stalking occurred in the year prior to the attack. Stalking is on the chart when you're evaluating the lethality of a particular case. Although we're not going to directly go over a lethality chart, Jacqueline Campbell has put together an excellent one. You can Google her. And I would say for those of you doing domestic violence, particularly protective orders, you need to do a lethality assessment. You need to determine what exactly is the risk of homicide to your client. And that is information that is going to tell you what steps you need to take in order to best protect your victim. And I see at the top of the slide that it does have Jacqueline Campbell's information there. Okay. I'm going to scroll through this because what I want to talk about now is some of the things that you can do to help your clients as far as documenting the evidence. You want to make sure that your clients are looking at their phones. We have smart devices everywhere. Your location is in every single app that is on your phone. Google has your location on. You need to sit down with your client. If they don't know how to do it, you can assist them or send them to their service provider. Go through every single app and turn off the location. You need to do that on a regular basis. If you believe that there is spyware of some sort that has been downloaded on a client's device, there are a couple of things they can do. They can go to their service provider and have them go through it. But a really easy thing to do is back up their data and do a factory reset. One of the things that we also see big time these days are tracking devices. They can go on the car, they can go inside the car, they can be put in the pocket of a jacket, a backpack, or even inside a stuffed animal. So when you are sitting down with your client and you're talking to them and they're saying, you know, I went to Planet Fitness the other day and he showed up there and I don't know how he showed up because it's not a place that I normally go. You need to have the conversation about tracking. You need to have them look around the vehicle. They can take it to someplace like Jiffy Lube and put it on a rack, or they can buy one of those scanners off of Amazon for around $50, and then they can use that to go around the vehicle. They can also look in the vehicle itself around the wheel wells of the car, look in the trunk underneath where the spare tire is. There was a case when I was on the bench where someone had hid an Apple AirTag in the spare tire compartment. They're small enough that they can be hidden just about anywhere. So you want to be able to give your clients as much information about where to look, how to look, and what to do. Make sure that if they find it, they should make sure they tell you immediately. They should report it to the police, and they need to definitely make a police report. Some other ways that people are using trackers is by those little tags that we put on our pets to track the pet. If they accidentally get lost, people don't often think about them. In addition, they also don't think about their security cameras that they may have inside their home. Make sure that the stalker, if it's an intimate partner or someone they dated, make sure that those passwords and usernames are changed immediately. And when they're changing passwords, which should be done on every single thing, bank accounts, credit cards, passwords for emails, social media, they need to use some sort of a phrase, not their child's birthday, not their anniversary, not something that would be easily to use. They should use a phrase, something like, I like peanut butter and jelly. And that way, that is going to protect their privacy and their safety in case the stalker or the abuser tries to access their information. Make sure that they do not accept phone requests or excuse me, social media requests from people that they do not know. Make sure that they block them. And if the individual is continuing to get calls on their phone from unknown numbers, don't delete them. That could be potential evidence that can be used in court. Make sure that they keep those text messages, send a copy to themselves or to you as the attorney to preserve them. Also, audio, video, and security footage, save those. Send a copy of whatever's been downloaded to a safe email address, to a friend's email address. And because that is something that could potentially be used in court as evidence. Also, make sure that if your client is active on social media, that they do not post pictures of where they are or where they have been, because some of those photos embed their location in the actual photo. And text
Barbara, we can't hear you. Something happened. Just give her a minute to come back here. I don't know what happened.
I'll go in the back and check.
Oh,
see.
that'd be great.
Yeah, let me.
Thanks.
And in the meantime, Vanessa, if you would like to answer any of the questions in the Q&A, that would be great.
Absolutely. The first question I see is, I have learned that sometimes, or the statement, I have learned that sometimes we use the wrong word. It's sometimes we hear harassment instead of stalking because we're not too familiar with stalking or stalking being used. So yeah, most victims of stalking don't even know, right, that it by the legal definition, they're being stalked. And so you'll hear most victims say, I feel harassed. I feel harassed. I feel just so alarmed. I feel violated. And again, harassment is a subset of stalking. So stalking, remember, a person commits an offense in the same scheme or course of conduct that one could constitute an offense under section 4207, which is harassment. And again, I want to note harassment has 8 different prongs of what constitutes harassment. It could be like this request that's or comment that's obscene. It could be threatening them or even their property. It could be making a false report or the telephone to ring repeatedly. That could place this person to feel harassed, annoyed, alarmed, torment, or embarrassed. And then I wanted to note that 7 and 8 of harassment states sends repeated electronic communications in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend. And it's not specific that it's just as emails, right? Electronic communications with the use of Instagram, Snapchat, Facebook, all of these new social media platforms, it could be those electronic communications of these repeated messages. This abuser creates these fake accounts, sends me messages numerous times every day. I've blocked this account, I've blocked that account. And the victim could just tell you, I feel harassed, right? But if it's in this same scheme or course, right, you notice that it's every day. It could constitute stalking. And then lastly, 8 under harassment states publishes on an internet website, including a social media platform, repeated electronic communications in a manner reasonably likely to cause emotional distress, abuse, or torment to another person, unless it's regarding a public concern. So this abuser every day on his status or her status posts my picture every single day, or posts that, I'm X, Y, and Z every single day. So it doesn't necessarily have to be to that victim, but my friends tell me every day this abuser is posting about me. And so that could be sufficient to meet the stalking statute and be sufficient to apply for a protective order. And the second question says, could you elaborate on the term unbroken for requesting a stalking protective order? Sometimes they go in and out without the behavior. Judge Stalder spoke about that. And so how I would answer this, it's unbroken for the applicant, not the respondent, right? Not the stalker. So the stalker may stop for a period, and that's okay. If the stalking has happened, that's sufficient. Even if they stop for a month and then it continues again, it can be unbroken for the stalker, right? But if it's unbroken for the applicant, meaning he stalked her all through the month of July, posted on social media, messaged her through Snapchat, followed her in her car, left notes. But then in August, they went out to dinner and spent a weekend, in Cancun. It's going to be difficult to prove that same scheme or course. And although we don't want to penalize that victim for falling into that category of that cycle and that power and control wheel, you may have difficulty proving stalking in that unbroken chain. So it's always for the applicant, it's always for the victim that it remains unbroken. And if you find a break in your chain, then you should ask. Don't just say, oh, well, you spoke to this person. Ask, why did you do that? I did have a case where a victim who had been severely stalked and harassed, at one point let this person come into their house and shower in their house. And when I asked this person, why did you do that? She told me, I thought that if I let this person do this one last time, it would stop. And I believed her, and we got a very lengthy protective order, and the court believed her, because that is typical for, these people wanting it to stop and giving in to their actions. This is why the stalker is doing that. But it may be difficult. I'm not saying it's an absolute decline or denial if you have that unbroken chain on the part of the applicant, but you may be able to, like the Judge Stalder said, you may need to look at the context and explain why that chain was broken. Judge Stalder, would you like to answer the last 3 or 4 questions? If you're with us. If not,
You're with us. Oh,
You're muted, Barbara.
I'm so sorry. I am
you go.
having technology issues today
Okay,
in
we
this
have just
world in which we live in.
probably
I just
one more
want to
question.
before I can't see the chat for the questions, but I want to leave you all with one thought about stalking. Keep in mind that stalkers may have undiagnosed mental health components. They may stop for weeks, they may stop for months, they may stop for years, but something may trigger their behavior to come back again, which is one of the reasons why stalking protective orders are granted for longer periods of time, because we never know when they might pop back into the life of the victim. Thank you all for indulging me.
Very good. So anyone else who had this has started your video. Okay, now I can. Anyone who has other questions on this topic that you've put in the Q&A, if you will just wait until the end, we will go through and answer the questions. The speakers are mostly will be here until the at the end of our program. Okay, is on cultural sensitivity. And the 2 speakers first will have Judge Richard Bell, who actually is my associate judge here in the 387th Court. And then we will hear from Carvana Cloud, who's founder of the Cloud Law Firm. And go ahead, Judge Bell.
Okay, let me make sure you can see my slide.
We can.
Everyone? Okay, great. All right, the topic that I'm going to speak on is cultural sensitivity. So what is cultural sensitivity? Why is it important to you? And why is it important to your practice of law? I think that probably if we self-analyze ourselves, most of us got into the practice of family law because we have a desire to help others. And not only that, but probably also a desire to be an exceptional lawyer, striving to be an exceptional lawyer. That's why we come to events like this, is to get better at what we do. And recognizing that the people that come in and meet with us, they need help. And in these domestic violence cases, they not only need help, but they need protection from us, or need us to help them protect themselves. And so when they're going through these difficult times of their life, or these difficult phases, they're coming to us, asking us to help them, guide them through that time. And that can be a heavy obligation, or a heavy burden on your shoulders, because we have a limited window in that initial consultation to make sure that we convey to them that we're competent to handle the situation, that we are going to be able to navigate the process and minimize the risk to them. And if we don't effectively do that, there's the risk that they'll just elect to stay in their current situation. So our job is to not just explain to them the law and the legal process, but it's to come up with a plan to help them get out of that situation in a safe way and in a way that alleviates their dangers that they perceive that they're going to have to go through. And I think a culturally sensitive lawyer will recognize that there are certain groups of individuals that are going to have additional challenges, additional obstacles uh, in their situation, and be able to address those moving forward. So before we get into the objectives and what I'm going to cover during my portion of the presentation, is I want to give a thank you to the organizers, U of H Law Center, Judge Heppard, Judge Stalder, Ms. Coulter, and Christina. When they asked me to speak, these organizers plan this stuff months out, right? And so when they asked me to speak on cultural sensitivity, I agreed to do it. But when I started getting prepared to do the PowerPoint and what I was going to say and doing research, getting ready for this, I thought to myself, they couldn't have picked a better topic for the current state of what's going on in the world. And for two reasons. One, we live in this area in a complete melting pot. Every morning when we have docket call, we'll have 15 to 20 cases, and we'll have in that probably 12 different cultures, religions, races, and it is a very diverse community that we live in. And so cultural sensitivity is something that we should all practice and get better and better at. It is a process. But the second reason I think the timing of this topic is so important is if you look around, I can't remember in my adult life ever feeling like there was as much discord out there as there is right now. I mean, you just turn on the news and you listen to the rhetoric being exchanged between individuals that may not necessarily agree with each other, and it's disheartening. So we're going to talk about cultural sensitivity today and how it impacts your individual lives and how it impacts your individual practices and how it impacts the clients coming in front of you. So today the objectives are going to be to evaluate the challenges facing survivors in certain groups. I've just picked 4 groups to discuss. We're going to start with LGBTQ and then move into minorities, disabled individuals, and then follow up with elderly individuals. And then to wrap up, I will end with some strategies on how to create a culturally sensitive office and some tips on how to do that. So the first group that we want to talk about is LGBTQ. Some unique control factors that they face, and I've given you the power and control wheel. We're not going to go through all of those, but some of the factors that they face from abusers is an abuser threatening to out them to family members, coworkers, or friends. Many times they'll try to isolate them from the LGBT community. And something that we see a lot of now is that threatening to take kids away. There are a lot of state legislatures that are not, their laws aren't moving quickly enough to get in line with Obergefell. You may have situations where a party feels like they don't have standing or the ability to go in and seek custody or visitation rights of a child in same-sex relationships. And even if the state law does allow that in your jurisdiction, the individual that's coming in to see you may not know that because they may have heard from other individuals, they may have heard news articles that they read that say they don't have that right. So just recognize that that may be a barrier that they perceive to getting out of their relationship and be able to address that with them. Some additional barriers in LGBTQ seeking assistance is the danger of outing themselves. I think this is very common when you're dealing with especially young adults or teenage dating violence. Many times they have not come out to their family and their risk of reporting that they're in an abusive relationship may cause them to have to open up to their family about that, and then they have the risk of rejection or isolation from their family members or friends and people in society. So recognize that that's an issue. Lack of LGBTQ friendly assistance resources. And the research that I was doing preparing for this, it seems like the main issue is with gay men finding shelters. That's the nationwide kind of the number one need out there, is they have difficulty finding resources. Fear of homophobia from service providers or non-LGBTQ survivors that are living in a shelter. And then what's common with a lot of groups is just low confidence in the reception that they're going to receive from law enforcement, or if they're going to be treated fairly by the court system. Minorities in domestic violence, some statistics that I found fairly staggering that I'd like to share. First, Black women are almost 3 times as likely to experience death as a result of family violence than a white woman. And while Black women only make up about 8% of the population, 22% of homicides that result from intimate partner violence happen to Black women. And studies show that they are also less likely to report or seek help when they are victimized. So what are some of the barriers that minorities face in reporting violence? First is, again, distrust in law enforcement and lack of trust in the judicial system. Many times there may be a higher poverty rate, which leaves fewer options available for a safe exit. Immigration status, this is something that Judge Heppert and I see a lot in our courtroom, but immigration status is often used as a form of control and as a reason that someone may not feel comfortable escaping their situation. And that can include a whole variety of things, taking their partner's passport, taking the children's passports and saying, you're not going anywhere because I've got the children's passports, threatening or withdrawing applications with immigration services, telling them that they're going to get deported if they report it. They'll get deported if they go to court. All of these things are concerns that client's going to have when they come in and meet with you, or potentially have when they come in and meet with you. Religious and spiritual beliefs and sense of duty to their culture, race, or family. I can tell you, I, in private practice, had a couple of examples of this where I had a client that came in to meet with me and had reached out to her family first, called her parents and said, I'm in an abusive relationship and I need help. And was essentially told, you need to be a better wife. You need to, you're angering him because you're not submitting to him, because you're not living the way you should live. And you need to go back with him and you need to make sure you meet his needs. And there are certain cultures where your client that's in front of you may have heard that. And they may be facing not only rejection from their own parents, but rejection from their entire community if they go forward with this process. And so knowing that that's a possibility can help you address that concern, come up with some ways to alleviate that concern. And quite honestly, some of this can be implemented in the courtroom. I mean, if you're in a divorce case and you are culturally sensitive enough to ask these kinds of questions and pull that information out of your client, I mean, we're telling a story in court when we're presenting a case. And I can't think of anything more powerful to a judge than having your client's own parents subpoenaed and come into court and talk about how they believe she should have been a more submissive wife. I mean, if that doesn't show a need where someone's on an island all by themselves without any kind of support system, I don't know what would to a judge. So if you've got, for example, spousal maintenance issues and things like that, and you find that you've got a situation like that, remember, you're telling a story to that court and you want to do whatever you can to maximize your client's chance of success. And sometimes just asking these questions may lead you to a more effective day in court. Control factors affecting the disabled. Here, many times the abuser will invalidate or minimize their disability. Sometimes they will not meet their needs for the day, so they'll refuse to allow them personal hygiene, not shower them, bathe them, clean them after going to the restroom, or clean them from themselves. Over medicating the individual, or refusing or withholding medication, denying them access to their healthcare appointments, stealing or withholding finances like Social Security checks, destroying or denying their access to mobility devices like their wheelchair, and then harming or threatening to harm a service animal. So again, just some factors that you might note in your brain to ask questions about when you're interviewing them to see if any of these are issues for them. What are some of the barriers that a disabled individual has in seeking assistance? Well, many times the very person that's engaging in the violent behavior or abusive behavior is their caretaker. So by reporting the abuse, they are risking that their assistance is going to be cut off. And so that is a difficult thing for them, because they feel like they're in a situation where they either live with the abuse and get the assistance, or get out of the situation and then don't have any plan for assistance. So you may have to help them formulate a plan on how you're going to meet that need in the, when they're getting out of the relationship. They may lack communication ability or lack communication devices, lack the ability to have transportation. Fear of losing custody of a child. Many times disabled individuals may not feel like they are going to be able to convince the court that they can take care of the child if they don't have that support system there. And that support system, again, may be the abuser. So oftentimes that'll be a concern of theirs, and they feel stuck in the relationship because they feel like if they leave, they may lose their kids or lose custody of their children. Many shelters do not accommodate mobility aids like wheelchairs and walkers. And then also a lot of shelters don't have just the providers or resources to meet the particular needs of a survivor with disabilities. And the last group that we're going to talk about is elderly individuals. And with elderly individuals, some problems that they have is lack of proper screening and reporting from doctors. It's a lot of times these abuse and signs of abuse are not reported by the doctors. Lack of services at the shelters to help them. Many times these individuals need help bathing or medicating, getting dressed, and those resources may not be available to them at shelters. Lack of family members or friends to support them. And then finally, limited mobility and transportation for traveling to and from court may be difficult. Again, just knowing these things may be their concerns. You can address them. You can explain to them, look, a lot of courts will give you the ability to appear by Zoom. That's something that we do in the 387th is if an individual needs to come to court by Zoom, we allow them to do that. And so there are things that they may feel are going to prevent them from being able to escape an abusive relationship, that if you're aware of it, you can let them know there's solutions to that. All right, so how does this impact us, and what can we do to become a more culturally sensitive lawyer, a more culturally sensitive person? I think first and foremost is educate ourselves. We need to learn about other cultures. That may be through reading, interacting, but also I think a good thing to do is just self-reflect and self-analyze where you come from, because we look at the world through our own individual lens on how we were raised. And that is something that you may have some implicit biases that you aren't aware of until you actually look at yourself in the mirror and look at how you were raised and look for things that may cause you to look at a situation differently or make assumptions about someone. I can tell you for me personally, I was raised with very little money, in very poor conditions in a trailer and trailer park. And I can tell you that for most of my young childhood and most of my young adult life, people that had fancy things, I made assumptions about them. One, that they thought higher of themselves than me. Two, that that stuff was probably given to them. They were spoiled in some way, and total inappropriate assumptions to make. But that was something that I was dealing with because it's just how I was raised. And so I had to recognize that. And again, that's a process that we have to see that we have a situation like that and we need to work through it. I can tell you one other thing that for me enlightened me was I was raised in a little small rural county, and I went off to college. I had never really been exposed to LGBTQ individuals. And my freshman year of college, about a month or so after being in college, my roommate opened up to me, and now he's opened up. He's open to the public, but he just opened up to me that he was gay. And at first, I was just kind of shocked. I'm like, oh wow, thank you for telling me. But I can't tell you how much I learned about a gay male from my friend. Living with him on a daily basis and getting to talk to him and get his insight on what he felt about things, how people made him feel, was incredibly knowledgeable for me, and it helped me. It's helped me throughout my life. So one of the things we need to do is be able to show initiative and get out there and interact with other cultures, with other races, with other sexes, so that we can grow in our knowledge and be better people and be better lawyers. Respect. Respect to me is a couple of things. Looking at your law offices, look at some of your forms. A lot of times our forms are outdated. And so you may have a situation where your intake form is husband, wife. Look at those things. You can change it to name and other spouse or spouse's name. Gender boxes, if you have those, you may have male, female. Add other to your intake forms. Things like that, where you're going to create a more culturally sensitive office if you make sure your staff is trained in these things, and also that your forms and the product that you're sending out are reflective of that. Avoid making assumptions about individuals. I've talked kind of how I'm guilty or have been guilty of that in the past. Every single culture, every single race, every single religion is going to have subcultures. Everyone in that is a unique individual. And so if you've had a situation where you had a bad experience with one individual, you can't just paint with a broad brush. And I know everybody knows this, but sometimes it helps us to hear this. You don't just paint with a broad brush that's how that culture is, or that's how that sex is. Be open-minded when you're interacting with individuals, and make sure you're giving them the benefit of the doubt and not making assumptions about them. In our interviewing skills, all these things that we've talked about today, I would say it would encourage you to implement in your interviews, asking them questions like, is there anything, do you have any other fears that we haven't talked about that you're concerned about in this legal process? Because it may be that there's something out there that you weren't able to pull out of them that they'll share with you, which will help you in your representation of them. Always try to expand your network. This is something I think we just naturally don't do this as individuals. Like, there's something about us that's wired to want to be accepted. And so when we go to a conference or we go to So we see 2 or 3 people that we know and we just gravitate towards that area of the room, or we gravitate to that table. And I would encourage you to try to get out of that comfort zone. Go sit at a different table. You go to an extracurricular activity for your kids, go sit next to someone that you don't know, that's a different culture or different race, and just strike up a conversation. And if you can teach yourself to do that more and more, it can help you, it can enhance you, and it can broaden your knowledge of different races, cultures, and individuals. And then finally, on the situation where, and this will happen occasionally, where you're in a court that's not sympathetic to the particular client that you have. And I think always the best choice there is to try to educate your judge. And most, that hopefully will work. But if you're in a situation where you're in a county that is not open to same-sex parenting plans, for example, or your particular judge and your particular judge in that area is not open to that kind of thing, if you can't educate them and get something by them, always remember that you have the right to go in and get a mediated settlement agreement, and take that mediated settlement agreement with you to court. And if the judge still refuses to accept your order after the mediated settlement agreement, then mandamus that judge. Because those are the kinds of things that your client deserves. And there's times where we have to make sure that we are standing up for their rights. And that is one of those situations where you need to do the uncomfortable thing of mandamusing a judge to protect your client. And if you do those kinds of things like that, you will find that striving to be an exceptional lawyer is something that will be achieved by you. I thank you all. I'm just about halfway through the presentation, so I want to make sure I leave Ms. Cloud plenty of time. And so that completes my portion of the presentation, and I'll save my questions to the end of the CLE. And let me stop sharing my screen.
Very good. Next, we have Attorney Carvana Cloud, and there she is.
Good afternoon, everyone. Can everybody hear me?
Yes, we can.
Awesome. Such an insightful presentation, and I think it goes perfectly, and it allows me to segue into talking about something that's very important. And many of the points you've already spoken about, and a lot of the survivors, the lawyers and the presenters talked about as well. I'm going to be speaking about justice for all, how we can, as attorneys, reimagine coordinated community responses to serve the underserved survivor. As attorneys, we have to make sure we are. Do you have to go to the next slide when you share it? Okay, all right. Every day we stand up. When I was in school, I always remember that we said the Pledge of Allegiance to the flag, and we, make sure we put our hand over our heart, and we said, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. That justice for all piece is super important. And the older I got, and the older I became, and more integrated in the legal system, especially on the criminal justice side, I realized that even though that flag says justice for all and it says freedom for all, it's not always that case in the cases that we deal with as lawyers when it comes to family violence. Next slide. So we're going to talk a little bit about, we're not going to talk about domestic violence as much as we're going to talk about intersectionality of race and gender and innovative and culturally relevant solutions. Next slide. Intersectionality of race and gender. It's super important. Judge Bell talked about how we're all different. At any one time, he can have about 12 different cultures, races, religions in his courtroom. And because we are a melting pot, we want to take some time to go through some of the nuances and differences in cultures of the survivors that we see mainly in our community. Next slide. Minority women are disproportionately affected by domestic violence. And again, as everyone has said, it's not saying that men are not victims of domestic violence. I actually represent someone right now. He's a male and he has been affected by domestic violence. But one of the things that we have to understand is that foreign-born women are also nearly twice as likely to be killed by an intimate partner than a non-intimate partner. And a number of those factors include, especially they're unique to immigrants, social isolation, traditional and cultural attitudes and norms about gender roles, poor socioeconomic status, and just simply a lack of divorce or employment or way to get out. And that simply makes them more vulnerable to domestic violence. Next slide, please. So we're going to begin with intimate partner violence in the AAPI, the Asian American Pacific Islander community. Next slide. With increases of immigrant migration, studies show that community-based samples of South Asian women have reported an increase of 40% of domestic violence incidents. That is huge. Factors associated with domestic violence in these communities can be attributed to patriarchal cultural norms, gendered racism, the arranged marriage system that oftentimes we don't think about, financial independence and immigration status, cultural resistance to disclosing domestic violence to protect the family honor. That is extremely something that is very, very, very important and critical in this particular culture. And societal views that normalize and support domestic violence under certain circumstances. So when you have that survivor that comes in and is a member of the AAPI community, these are some things that you can remember or take note of, because it will explain why they want to drop their case or why they don't want to move forward with that protective order, because they're frankly scared or there are different things in their culture that prevent them from doing so. Next slide. Barriers to seeking justice, homelessness, where are they going to go, especially if they don't work or they're not the breadwinner. And domestic violence is not generally seen as a prevalent problem in the South Asian community because of these stereotypes. They have limited friends in their community. There's a huge social stigma, and of course, language barriers, a limited English proficiency and language barriers. And that's just not unique to the AAPI community as well, but that's definitely something that impacts how they're going to show up when they come to us for assistance. Now let's transfer and talk about intimate partner violence in the Hispanic community. As Judge Bell said, I mean, when he broke down, we start talking about the various cultures and individual groups that we support. I wanted to make sure we broke them down and talked about specific ethnic communities, as it is critical. We're all very unique. We may be one melting pot, but we all are so different. And when I say all, I mean all of our different cultures. And so I thought this would be important. So let's go to the next slide as we talk about the Hispanic community. Here are some facts. 1 in 3 Latinas have experienced domestic violence in their lifetime. 50% of Latinas never report domestic violence. That may be surprising to some people, but others it may not be. The reasons are there's immigration issues, anti-immigrant laws. Latinas are half as likely to report abuse versus survivors from other ethnic or racial groups. And a lot of that is due to immigration, whether they have immigration issues or whether that abuser is struggling with immigration issues. They don't want him or her to go to jail, or they don't want themselves to go to jail. And frankly, that mistrust exists. And as a result, 63% of victimized women experience multiple acts of victimization. And a national sample of Latinas found that more than half of the women surveyed reported at least one victimization over a lifetime, and about 2/3 of those women had experienced more abuse than even that. And so these are some very startling facts that really pertain to the Hispanic community that we definitely need to be aware of when supporting this community. Next slide. The fear of deportation paralyzes. Right now, especially, in our country, in the world. We are, let me see how to say this. I think the title says it all. Fear of deportation paralyzes. And so instead of saying something and perhaps losing their children or being themselves deported or getting their loved one who they love who may still be an abuser, that fear of deportation paralyzes and they just suffer in silence and they take on that abuse and they say nothing. But especially now, we have to make sure that we share with them that no matter what, love does not hurt. And deportation, while it is an issue, there are ways that you can still get protective orders and you can still be safe without worrying about being deported. Next slide. Cultural considerations, I'll just go through these briefly. I've said some of them before, but I will tell you that Latinas reported seeking access to shelters less than other women from other racial or ethnic groups. This is actually the same for African American women as well. Of the Latinas who experience abuse, about half of them never report the abuse to authorities for a reason we've already discussed. They prefer to just keep it within their circle, telling family members, friends, while non-Latinas may be more likely to tell healthcare workers or clergy, folks who have maybe more support, are more mobile, maybe non-minority, may have the dollars, the ability to get out, to move out, to hire that lawyer to be able to do that work for them. Nearly half of Latinas in one study did not report abuse due to fear or lack of confidence in the police. And one of these studies even showed that about 4% of participants had fled their countries of origin in search of protection and safety from intimate partner violence. Next slide. Reporting can separate families. We've already talked about that as we see here. So threatening Latina survivors to take their children away is one powerful strategy that is used against undocumented non-English speaking women quite a bit. Because their children and their family mean everything to them. And so if you threaten to take their children away, I might as well, many of them feel that they might as well just stay in the situation than risk losing their family. Next slide. You go to the next slide. Let's talk now about intimate partner violence in South Asian, Middle Eastern communities. And when I say that, I'm talking about the areas of where folks come from: Egypt, Saudi Arabia, Turkey, Syria, Iraq, Iran, Persian, and Afghanistan. So we're going to be talking about quite a few countries that are represented in this particular group. Next slide. Here's some harsh cultural realities. A survey of 63 Muslim leaders showed that 10% of Muslims experience physical abuse in their homes. A study of 23 Muslim married female immigrants from Bangladesh residing in Houston revealed a 10% prevalence rate of spousal abuse. And a study of 162 women and 40 men was conducted in 202 Arabic American homes, 98% of whom were Muslim. And those interviewees approved of a man slapping his wife if 34% of women and 33% of men says if she insults him when they are at home alone. 17% of women and 43% of men said if she insults him in public. And 59% of both men and women says if she hits him first in an argument. So again, the misogyny is there. It is definitely prevalent. Sadly, a very harsh reality, but one that is faced by Southeastern women and men, mainly women from South Asian communities that we've discussed before we started. Next slide. So now we're going to switch over to intimate partner violence in the Black community. What's love got to do with it? We talked about this before. I know many of us have seen this movie. If you haven't, you have to see it. It's definitely one that is one that you definitely want to see and watch. And it's the story of Tina Turner and Ike Turner. And I tell you what, love doesn't hurt. That's where I got that from when I said that earlier. Love surely doesn't hurt. So what's love got to do with abuse? Let's go to the next slide and talk about it. Nothing when Black women experience intimate partner violence at rates 35% higher than white women. Not at all. I'm a child survivor. My mother is a survivor of domestic violence, and thank God she did not die. She is an amazing woman, but she falls into this percentage. And I witnessed it as a child, and I was very impressed with Denise's presentation. And I had to kind of sit back and take in for just a moment some of the realities that are still prevalent with me at 47, because I started seeing domestic violence in my home at the age of 8 years old. Next slide. So the prevalence, domestic violence is one of the leading causes of death for Black women ages 15 to 35. 29.1% of Black women are victimized by intimate partner violence in their lifetime. And while Black women only comprise 8% of the population compared to 30% for most white women, yet Black women are almost 3 times as likely to be killed as a result of domestic violence. African-American male perpetrators make up half of the arrests for intimate partner violence, and African-American women are twice as likely to be murdered by a spouse and 4 times more likely to be murdered by a boyfriend or girlfriend than white women. Next slide. Why is this? Let's talk about the backstory, okay? So we have to stats are one thing, and we could quote stats all day, but I'm all about understanding why. What are the root causes? What's the backstory? Well, the first is there's significant racism and social inequity that exists in our country. And that has been for decades. And unfortunately, while we've come a mighty long way, as my grandmother would say, we still have a long way to go. There's an lack of access to healthcare, educational inequities, economic hardships, and neighborhood and environment may not always be sufficient or a very positive place to live and or raise your children. And when you're faced with all of these challenges and barriers, it's going to create tension, and it's going to create tension that unfortunately can lead and often does lead to violence in the home. Next slide. Racism. African-American couples, because of their ethnic minority status and the continuing effects of racism, are more likely to experience life events and life conditions often identified as a risk factor for partner violence. A Black woman is 80% more likely to be convicted for killing her abuser. And many African-American women think racism is a bigger problem than sexism. And that's reinforced by the family structure and partners, and it certainly is why, and explains why intimate partner violence in the African-American community is underreported. The culture of mistrust has certainly been reinforced by many events, including some that are quite recent, as you can see here, whether it's back in the 60s at the top, at the height of the civil rights movement, when African-Americans were being mistreated. Water hoses were sprayed on them to stop them from protesting and having a voice, to Sandra Bland, to Eric Garner down at the beginning. And so some survivors are more likely to just endure the abuse in their relationship than appeal to attorneys, agencies, and law enforcement for assistance. And I didn't tell you this at first, but I am a former prosecutor and I'm a criminal defense attorney now. And so I've seen it from both sides. And so as a survivor, as well as having worked in the criminal justice system for 20 years, I have definitely been impacted by this work, and I've actually seen and heard survivors say all of these things, and so this is coming from my own experiences as well as research on why and how racism definitely impacts intimate partner violence. Next slide. So I will give you what I call a trigger warning when we talk about this case. But in April 30th, 2017, there was an initial call that dropped as a weapons disturbance, and this call involved a woman named Ashanti Hunter. Next slide. Ashanti was an Air Force veteran, a mother, a cousin, a daughter, and she made all the money in the household. And she dated a man who was extremely abusive to her. And for 4 years, she called the police and she reported being strangled. She reported being hit. She reported being kicked. She reported the children being harmed. And each time the police came, nothing was done. When the police came and she said she was strangled, they said she was too dark and they couldn't see any marks on her, and so she wasn't strangled. There was another time the police came, they were called. She called the police and they said she had a knife in her hand defending herself. Well, they put her in the back of the police car and were going to arrest her until he said, "Oh, no, you can let her go. I'm fine." That abuser used his manipulation tactics and power and control to have her released from being arrested. But then again, he was able to maintain that power and control and continue to abuse her. The final call came when the neighbors heard them arguing and asked the police to come out. And when the investigator called her back to follow up and get more information, to offer protective orders and all of that, she said, "I'm sorry, I don't want to have anything to do with the police. My children are going to be put in CPS, and he might go to jail, and I don't want him to go to jail, and I just don't want to do anything. You haven't been here for me, and so I don't need you." Sadly, 82 days later, she was killed. And so the picture that you saw earlier was her as she lay in that car and she was murdered. She was killed. He shot her point blank range in her head and her chest, and her children were in the car. So you can only imagine the type of trauma and rage and fear that the children had. And she was running into her cousin's car. She had called her cousin. Her cousin came to pick her up. And she was getting in the car and they were about to take off. And sadly, she ran out of her shoes trying to get into that car to get away. And he still killed her because that was the ultimate. That was the ultimate. You don't run away from me. You stay with me. I am your abuser. I am in control of you. And when she tried to leave, she was killed. Carvana, why does all of this matter? Right? Why does all of this matter? Why is it important that we know and we understand about different ethnic cultures? And why is Ashanti's case important to us? Well, it provides us knowledge about the socioeconomic, cultural, and political context within which immigrant and women of color experience domestic violence. And that's critical because they are disproportionately impacted by domestic violence. And that needs to be known and said as many times as possible. Law enforcement and community-based services for all survivors, especially immigrant survivors and women of color, must respond to their unique and specific needs. That means access to skilled interpreters so we can get rid of the language barriers, shelters that respond to culturally specific needs. And that means everything from allowing them to pray when they need to pray, to providing the food that is appropriate for them, and making sure they have assistance with maintaining their legal immigration status and providing U visas where appropriate. Interagency coordination and collaboration among victim service providers are key, and they play a key role in activating community resources and awareness. So while you might think it is your client that you're representing, ultimately there are other systems that are involved and many times are interconnected or should be interconnected. And that's why we're talking about how coordinated community responses can be more culturally sensitive, because we all have to be woke. As my daughter says, "Mom, you have to be woke. You have to wake up." Okay, but we all need to be woke about how we can work together to create a more culturally sensitive environment for our clients. Next slide, please. We cannot be a cookie cutter program. This is one of my favorite quotes from an advocate. She said, "We cannot be a cookie cutter program. We cannot have a survivor to fit a mold that we have. Everybody is different. Yes, we are a melting pot, but as I just explained about each of these different cultures, very brief, although albeit very briefly, we know that they are all very different and they all require certain things and they have certain needs that we must adjust to. And if that means changing your forms, if that means having certain people in the office who can speak with them, who can relate to them, who will be able to be more likely to for them to answer the phone when you're following up, you need to make those adjustments. As an attorney, as a shelter organization, as an advocacy organization, it's critical. It's critical. It's the difference between life and death in many cases. Next slide. So let's talk about some innovative and culturally sensitive solutions, changing what we've always done to save lives and empower survivors. Next slide. So we need to collaborate across systems. And so we're going to talk about a few things that have been done in Harris County and some other places that have been very helpful to enhance cultural sensitivity. Next slide. Here's the issue. Justice delayed is justice denied. So while you have law enforcement, you have prosecution, and you have family courts, then you have shelters and programs, and then you have the forensic community. Each one of them works in their own silos, and they do what they do very well. I have no doubt each and every one of you are amazing warriors who are doing it and the very best that you can to help and advocate for your survivor. But the fact of the matter is that there might be information from the forensic community that law enforcement has received that you might not have, but that may bolster and improve your application for protective order in family court. And the same with shelters and programs as they're working to get them homes or shelter or any other additional needs that they might, or any additional things that they may be in need of. Next slide. One of the things that you have to do, one of the things I know that we did in Harris County is we really did a deep dive into the data. And we found that, you know, I know Ashanti, I mentioned, was strangled several times before she was killed. And sadly, strangulation is, it preempts many homicides. We were filing 4,300 strangulation cases from 2009 to 2016 and dismissing 2,031. So almost 50% of those cases were disposed without prosecution. So given that we have such a high homicide rate, I begin to think, what could we do to change that? What does that look like? Is there a culturally sensitive solution so we can deal with these cases and get these survivors the support they need? After all, the law was passed. So how can we enforce the law? Next slide. 90% of strangulation offenders have prior history of domestic violence. And so again, domestic violence homicides are preventable. If you've ever heard me speak, I always say that, and I truly believe that. And there is, it may go from a threat to a kick, to a slap, to a punch, to stalking, to a terroristic threat, and then strangulation, and then unfortunately homicide. So you'd be surprised if you look at prior history of that person, especially if they're strangulation offenders, they have prior history of domestic violence. Next slide. So one of the things we decided to do was to say to law enforcement, just stop. Let's take a beat here, all right? Let's figure out what we can do and how we can all work together so we can make sure that strangulation cases are properly prosecuted. So in Harris County, we have 85 plus law enforcement agencies. And before the strangulation charges can even be filed by intake, they have to complete a strangulation supplement. This supplement was created by Kelsey McKay, who is an extreme, she's an expert and advocate in this space. She created this supplement, and it doesn't just look for marks on the neck. Let's go to the next slide so we can see the things it asks, and you can just press each button and press the button each time, and it can show the different things. It asks, was your breathing normal? It asks, how did your throat feel? Did you experience any dizziness during or after the strangulation? Swallowing changes during or after? Did you feel any physical pain? Those are questions that are often asked. Those are questions that are asked on the supplement. They were never generally asked before, but those are signs and symptoms of strangulation, even petechiae, the redness in the eye, that show that somebody was strangled. This information is critical to be used and can be used in a protective order court hearing. You can subpoena this information from the forensic examiner or from the hospital, and you can have this information to use when you're asking for that protective order or you're seeking additional safety and support for that survivor. Next slide. we must start prioritizing high lethality cases. You're going to have a variety of folks that come into your office with a variety of different issues as it relates to family violence. But when you are, and somebody said this earlier, I think it was Judge Hubbard, you have to look at high risk and lethality. You have to do a lethality assessment. You have to assess the traumatic impact. You have to look at the long-term and short-term health consequences that the survivor is experiencing, and know that the need and demand is overwhelming. And sadly, prior to 2009, strangulation cases were not even being filed. That law was only passed 15 years ago. So many of those cases were being dismissed, so abusers were not held accountable, and they maintained power and control. But fortunately, the legislature saw different, and now that is not the case. And so it's up to us as advocates, as lawyers, to make sure we are prioritizing the most dangerous cases, because the most dangerous high lethality cases can lead to homicides if not dealt with up front. Next slide. Restorative justice. Understanding this, I envision a world where the burden of victim safety is not solely borne by the survivor, but is more squarely placed on the shoulders of the systems designed to protect them. And when we do that, the result is offender accountability with culturally specific advocacy without re-victimizing the survivor. That's where we're going. And that's what restorative justice is. And that's what it does. And so when we're able to do that, we're able to provide a next level type of experience and advocacy for the survivor that empowers them and doesn't put all of the burden on their shoulders. So that's why I talk about systems connecting and interconnecting so that they can work together in a way that supports the survivor. They're already doing the work. I told you, we already have these silos doing great things, but oftentimes there's not enough communication between them. Next slide. So one of the things that we did in Harris County and that we still do now is we have a team called the Domestic Abuse Response Team. It's called DART. And DART is started in Los Angeles, California. And I got the idea from them. We changed it and we added a forensic medical component to it. But what it is a crisis response team that inspires victims' trust in the criminal justice system by providing immediate safety and linking high-risk victims to responses within minutes of them dialing 911. DART teams provide immediate scene safety. They facilitate the filing of criminal charges when applicable, and they coordinate with community partners to coordinate the continuum of care for victims, like medical forensic services, temporary shelter, food, mental health services. Forensic examinations are done as a part of the DART process. That was key because many survivors didn't want to go to the hospital, didn't have transportation, didn't have insurance. And so at least by being seen by a medical forensic nurse, they are able to get an upfront idea about where they are health-wise. And then if they determine, and if once that nurse says, look, I think you should go to the hospital, then we have the ambulance come and transport them. But they're able to do all of that at one time, giving them all of the support they need without just being handed a piece of paper and saying, go here, just look on this paper, go here, go here, go here, go here. That's a lot when you're traumatized, when you're under stress, and you're terrified that he or she may come back and abuse you further. So DART is a responsive team that is designed, it's a homicide prevention team, but it's an immediate response team. And we work this program with the Houston Police Department and the Houston Area Women's Center, and also the Empowered Survivor, which I founded in 2021. They manage the forensic nursing portion of this program. Next slide, please. Again, DART focuses on high-risk cases. And when I say high risk, I'm talking strangulation, aggravated assault where a weapon is used, continuous family violence offenses, all of which you all are familiar with. They identify the most traumatized victims and connect them to services, recognizing long and short-term health effects. People don't really think about that, but that was really important to me. When I studied when I prosecuted Ashanti's case, and I kept hearing over and over and over again how much she suffered and health-wise, what she went through and what she experienced. This is not just about locking someone up. It's about making sure that survivor, again, it has restorative justice. And that is key. Strangulation also overlaps with sexual assault, human trafficking, elder abuse, and child abuse. But DART ultimately was designed to decrease homicide rates, and we wanted to increase conviction rates on non-fatal cases so we didn't have constant recidivism. And also, it's critical that you know that DART, and when you're attacking domestic violence head on, especially these high lethality cases, you're preventing officer homicides, because domestic violence offenders are more likely to kill and harm our officers. And that is absolutely something that we cannot have happen. Next slide, please. So we're building relationships, we're finding common ground. This is what this is about. We have our systems advocates, our police, our prosecutors, our family courts, our protective order courts, and we're working with our culturally specific advocacy groups that collaborate with the systems-based providers, and that creates the common ground for that survivor to feel not only safe, but empowered. That piece, that empowering piece is critical, because not only can they live, but they can thrive, and their children can expect and see something different in their home, and that will help them not continue the generational effect of violence when they have a partner, or when they get married, or when they move forward in life. Next slide, please. So culturally specific advocacy is educational. The judge talked about that earlier. We have to educate ourselves, understand the definitions, the warning signs, the behavioral cycles, and the cultural competence. We have to do training modules. We don't all know everything about everybody or every culture. So we have to be willing to learn and step back and say, look, I don't understand this. Help me understand this, because I need to be able to help all my clients. Encourage communication. That means positive and supportive interactions. Enforcement of policy rules in places such as shelters, or even within your own office, and have a better understanding of underlying causes in the context of abuse. That's critical to having culturally specific advocacy. Next slide, please. Before we do anything, we have to address, and I said this earlier, trauma and the root causes of violence. You can't help a person go forward until you know where they've come from. You have to listen and ask questions that will help you provide the support and services they need, all while understanding that justice looks different for every victim. For my mom, it was making sure that we were okay, right? There are other folks that want to make sure that they haven't been harmed for long-term purposes. Everyone is different. So again, we can make assumptions, but most importantly, we certainly cannot judge when we encounter or supporting a survivor. When that survivor walks in, we have to listen more than we talk. And we have to ask questions that will help them feel like they're loved, like they're supported, because you have to understand that they're coming from a place that they've never been heard. And so this is new. And like the picture here shows, I thought he loved me. Yeah, that's real. That's real. You have to understand that. You can say, I thought she loved me. Whatever it is, we have to make sure we are asking that. And the final slide, you can go through to the next slide. I'm sorry, I thought that was the next one. You can go through this. Trauma creates change you don't choose, but healing is about creating change that you do choose. And when we are able to work together, we're able to heal, and again, not only make sure that survivors can live a life free of violence, but can truly thrive. Thank you very much.
Very good. Thank you, Ms. Cloud. That was very good. And at this point, yeah, once we unshare, we are all back. I think everybody. In case anybody has any questions that you already did not get answered. Oh, here we go. Got somebody. Oh, this is for you, Carvana. It's Carvana.
Okay.
You read it. Are there laws regarding domestic violence in other countries that you would like to see implemented in the U.S.? I guess that some of us can answer that too.
Yeah, I just did a presentation for the Texas Council of Family Violence. They had a statewide conference this week or a little bit earlier. And they were explaining to us that South Africa, that a lot of different countries have laws against domestic violence. Okay, that's the answer to that. A lot of different countries do have laws. South Africa and Australia were highlighted as two countries that were really, 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 I guess, ahead of their time and making sure that survivors were protected from guns, from the use of guns, from their children not being taken away from them and things of that nature. And while I don't have every single law that each country provides, I know those were two countries that stood out to me. And that was something that I said that I was going to study. And as this legislative session takes place here in Texas, I would encourage all of you to think about what laws you want to see on the books. We as attorneys have to be very, very, very aggressive and not afraid to make sure that we push legislation forward that make laws that protect our survivors.
Yeah, I will say that at least at one time, New Zealand had laws that if there was a finding of family violence, that the perpetrator of the violence, and there were children, got no visitation, no access to the children until they proved to the court that they could safely parent those children. And we're always nervous about doing that. Any other questions? Just, you can still put it in the Q&A.
Can I say something to the audience before we start to wrap up? Thanks to everyone who has participated on this Zoom today. This is a presentation, we do this every year annually, usually at the end of October, which is Domestic Violence Awareness Month. And we oftentimes will find ourselves in November doing this presentation. I think this is probably the 12th year for Janet and Barbara and I doing this, and some of the panelists have been on, Judge Bell has been with us now for the last several years. We want to continue to do a good job. We would appreciate any feedback you all have in regard to content, things that you think we could present. If you have speakers that you think we could engage that would, again, be subject matter experts on domestic violence, please feel free to reach out to us directly or to Christina at U of H Law, so that we can continue to put on a presentation that is educational and that is useful for you in your day-to-day practice, or if you are a judge who are hearing these cases. We really want to make sure that we elevate your ability to recognize and hear from your cases, the things that are needed to make the right call and the right decision when making orders in your court. So again, we appreciate everyone who attended, and we need to hear your feedback. Also know that this will be available online at a subsequent time for those of you who want to share with individuals who were not able to get on this live Zoom presentation, but want to get this particular information. Again, we're grateful for your attendance, and we would love to hear your feedback.
I have a question here. Judge Stalder spoke a bit about how interference with custody could amount to the necessity of a protective order, and Ms. Coulter answered another Q&A question a bit more specifically. Would you all, including Ms. Vine, speak about how these issues might interact with parental alienation in SAPSR cases?
Yeah, so I'll be brief and just say that the question was posed in the earlier in the Q&A about whether or not it was appropriate to seek a protective order when you have an existing SAPSR and orders for visitation, and maybe visitation is being denied. And I explained to that person who was posing that question, that protective orders are really about protecting the individual who is being harmed. And so if there is a custody order in place and you are threatened or physically harmed as a result of trying to exercise your visitation, then it might be appropriate to pursue a PO in that regard. But what what is most important is you have an existing order and it needs to be enforced if it's being denied. And so an enforcement is probably the more appropriate standard of seeking legal recourse there, not a protective order. Again, now, if you're being hurt or harmed at an exchange, threatened, and those types of things, then that would be more in alignment with the protective order. But those things need to be counseled and advised, and you really do need to think about the facts that you have in front of you when you are consulting with people who are asking for your guidance on what is the right legal filing to make. Your judgment could be the difference between being successful in court or making it very difficult for these parties to continue to coexist and or try to exist as co-parents or parents who have children in common. I see and hear the other part of that question, which is parental alienation. I will defer to either Diane or to Barbara to follow up if you want to add anything about that issue of parental alienation and the legal system.
Well, I would just add to that, sometimes not only enforcing the order, but also in extreme cases, especially like if you feel like there's parental alienation going on, and that's part of the reason behind the refusal to allow visitation, is consider a modification. Enforcement's only going to give the judge the limited ability of enforcing that order, whereas a modification opens up a lot more options for the judge to modify and use a stick, carrot, those kinds of things to make sure the visitation's progressing. So I would consider also filing a modification in those cases.
In addition, just to touch briefly on that, and I think I'm on topic, but if I'm not, I apologize, is that the one thing you don't want to happen is to file an application for a protective order and have your judge thinking that they're having to delve into the child custody case. You need to be able to show, as Maisha said, that this is for protection, that you're not getting into the child custody. Here in Harris County, I can tell you that the 280th is very concerned about things like that. They will question the attorneys about it. So make sure when you are doing these cases that you are very clear that it is for protection and you're not doing it for the purpose of child custody type issues.
And there's a follow-up question that I think we've mostly already answered. So the follow-up question is about parental alienation. Does the emotional/mental harm to the child qualify for the targeted parent to apply for a protective order for the child? I think we've answered that, but it's important to focus on the safety issues. Potentially, yes, but a lot of times it's easier and better to present those things to the court in, say, a modification, as Judge Bell said.
In addition,
go ahead.
Excuse me, Diane, the one thing you have to remember about, you have to read the law and what you have to prove as far as the legal issue. I'm sorry, Diane, please go ahead.
No, that's okay. I just wanted to add that there are a lot of clinicians that do not do custody evaluations. That is a separate skill set. I don't do them. And that is a separate skill set. You can still work with these children, but it's more along the lines of providing a safe, confidential place for them to express their feelings and to get clarity on their feelings, because a lot of times they'll walk into a session and they're basically saying what someone else told them to say. And so for kids like that, first of all, I would never see them virtually. They need to be in your office where you can put eyeballs on them, and where any of the other parents are in another room where they cannot hear. And what parents can get in terms of feedback about the sessions is, this is what we're working on. And in general terms, expressing being able to express their feelings, being able to express their thoughts. And then, are they making progress or not? And that's it. They don't need a lot of detail. Kids are not going to tell you anything if they think that you're going to turn around and then tell their parents what they just said.
Yep.
There's no point in taking them to therapy for that.
Mhm.
So they need their own space to do their own talking, and the parents can know they're making progress or not. And I don't do it virtually because people are in other rooms pretending they're not there, pretending they're
Yeah.
not listening, and they certainly are. So that's my feedback.
That's very good. That's the same way Judge Bell and I interview kids, or what judges interview kids. They sometimes come in and they start telling you what one of the parents has told them to say. So we can usually tell that. So hopefully that answered your question. If anybody else has any questions, or do you guys have any other comments? We have no new questions in the Q&A at this time.